It's something to do with democracy, election, and electoral justice and democracy. So we are going to have that, so we can just sit back, relax, and let Eddie take us through the same. Thank you.
Hello, Kuti. I guess you could smile and say, honey, I'm home. But the gun is a bit of a turn-off, isn't it? You don't want me to shoot you on your back now, do you?
Who the hell are you?
Munira Hussein. I'm with a special branch of the police force. I could shake your hand, but then again, the gun thing, you know?
You know, I always thought that they would send big men with big guns to come and get me when my
Instead, they sent a tiny woman with a tiny gun. What's life without a few disappointments?
So, what now?
You've heard the rumors. They're true. You are going to be Mr. Opio's guest until you testify to your charges of treason.
Utaongea matukupa glucose. Kanyaga kichwa kwanza atukwese. Kanyaga kichwa atukwese. Tukifika alikuwa anajifanya mwanaume. Sasa utajua wanaume ni kina nani. Sasa anaangalia hapo. Anaanza kutoa yoga nyuma moja utaona sana. Sasa serikali si mama yako. Jana utaona.
Are you ready to make your confession yet?
Oh.
You know how much I don't like silent treatments, right? I'm bound to react negatively with beatings and scalding hot water showers and all. Do we really want that again for you?
I'm just bored.
Huh?
I said, I'm just bored.
Oh, Koti. Koti, my dear. Come, I want to show you something. Do you want me to say please, or do you want me to send the boys down with the batons? Koti, my dear. I'm sure you're familiar with your Marxist lecturer here, Dr. Nono, I believe. Takes you for constitutional law at the University of Nairobi School of Law. Yeah, by the disgusted look on your face, I can tell the two of you are well acquainted. He's the one who's been sharing the Marxist propagandas with you, right? Just say yes, and your life can go back to beautiful again.
I don't know what you're talking about.
Have you ever been to an execution, Koti? It's pretty horrendous. And beautiful. Really beautiful. A gun is cocked, a trigger is pulled, and a bullet flies into a man's head and poof! Goes off like a light. Would you like a demonstration? Or do you have a confession to make?
I told you I am just a poet, you psycho. I recite poetry, that's all I do. What is wrong with you? I've told you that many times. No! No!
If you confess to the charges of treason levied against you, we'll arraign you in court, and you'll spend a few years in jail, and then you'll be released. Or you could testify against another one of your lecturers, and I promise you, you will be released. You'll graduate top of your class, and you're guaranteed a government job once you graduate. And if you don't, we'll take you down to Old Onyusabuk, kick you out of the car, and my guys will stand behind you with AK-47s ready to shoot. And I will say, run! How far can you run, Koti? Until you're just another dead body out in the fields.
Okay. confessed. But only to Mr. Opio.
But that's not how it works.
Look, you can get your confession, or else I'll just be another dead body out in the fields. The decision is yours to make.
I hear you'll only confess to me. Is that an honor, or is it a waste of my time?
If it was a waste of time, then it suddenly wouldn't be me.
Shall we dispense with the games then, and get on to it? This is a sheet of paper, which says you have been coerced by the University of Nairobi School of Law Dean, a Dr. Kanene, to write and recite poetry against the government of Kenya. Sign it.
Mr. Opio, I would like to ask you, on behalf of myself and all Kenyans, to take this sheet of paper, roll it up in a nice ball, and shove it up your ass.
Have you ever been to an execution? You don't want me to shoot you on your back now, do you? And my guys will stand behind you with AK-47s ready to shoot.
Mwenyezi Mungu aibariki Kenya yangu, kwa jina la Baba na la Mwana Roho Mtakatifu, amina. Kwa jina la Baba na la Mwana Roho Mtakatifu, amina. Ewe Kenya inji yangu, ewe Kenya baba yangu, ewe Kenya mama yangu, sitakuacha milele. Nguvu zangu nimeziweka mbele yako, bibi yangu na watoto nimewaweka mbele yako. Tabu zangu shida zangu ziangalie Kenya yangu, tabu zangu shida zangu ziangalie Kenya yangu.
And so that raise questions, and we want to ask ourselves, do we have democracy? You know, some of the questions you just want that are raised by some of this. So at this point, I should invite the session, that is the panel discussion that is coming on board, and my colleague Sarah should be heading this. So karibu Sarah.
Mic check, okay. You guys can, yeah, this is great. Okay, so we're just going to start off with our panel discussion. And thank you, Beatrice, for that introduction and summary of the film. So based off that film, we're just going to have a guided panel discussion just to discuss on some of the issues we have seen in the film and then now relate that to our theme on governance. Yes. Okay, so all our panel has the mic, so I'll just, are they 3 or 4? Yes, so perfect. Yeah, so I think I'll start by introducing our panelists. So we have Clarice. Maybe you can just tell us your name and who you are.
Good morning, everyone. My name is Clarice Oganga. I am a human rights specialist. I work with the United Nations Office of the High Commissioner for Human Rights. Thank you.
Yes, so we'll move to Timothy.
All right. Good morning, everyone. Good morning. Are you not excited to be here? Yeah? It's cold this morning. My name is Timothy Thondu. I work with International Justice Mission, and I'm happy to be here.
Thank you. Lillian?
Good morning, everyone. Good morning. I hope my mic is working, yeah? I'm also not sure it's... All right, sawa sawa. Good morning, everyone, once again. My name is Lillian Gathua. I'm an advocate of the High Court of Kenya. I'm also a certified secretary, and I work at Transparency International Kenya in the Policy, Legal, and Institutional Frameworks Department. Happy to be here.
Yes. Can you guys hear me? I'm not sure even this one is working. So now I'll invite Lillian to start us off. And based on what we've seen, what can you tell us about police accountability and just relating that to the violations we've seen, we've experienced? Yes, thank you.
Okay, thank you so much. So I'm going to start with giving a brief background of Transparency International Kenya and the work we do in relation to the discussions here today. So we are a not-for-profit organization founded in 1999 in Kenya with a vision of a corruption-free Kenya. So we work towards fighting corruption in the country. We're part of the global movement called Transparency International. We of course, work around issues of good governance. Corruption is an issue of governance and a lot other things. So we promote social justice and good governance and particularly enhance transparency and accountability in the country. So one of the areas we focus on is policing and service delivery in the policing sector, and especially towards enhancing responsible and accessible justice to citizens, of which the police are a critical actor in the criminal justice system in this country. So when you look at human rights violations in elections, yeah, in the electoral cycle, before, during, and after elections, the police play a critical role in terms of enhancing electoral security, and this refers to personal security, physical security, information security, and they play a big role in maintenance of law and order, ensuring peace and safety during the election period, that is before, during, and after. So when we talk about human rights violations, you cannot fail to talk about the police. Of course, there are a lot of issues around elections and the role that the police plays in terms of maintaining public order, enhancing safety and security, and how they conduct that. Of course, they're supposed to do this within a framework of the rule of law and human rights, upholding human rights and freedoms. So we're able to see that there is need for accountability in the execution of their mandates. So in terms of police accountability and oversight, I would say that we have two main bodies established for this. We have the Civilian Oversight Body, which is IPOA. Unfortunately, they're not represented here. But we also have the Internal Affairs Unit of the National Police Service, a body which is really not known by a lot of citizens, surprisingly. But it is established under Section 87 of the National Police Service Act, and is mandated to investigate and promote proper police conduct. So it investigates police misconduct. So we're going to have further discussions around this. I'm not sure whether I should talk about the mechanisms for citizens to engage with these bodies right now. But basically, let me say that in terms of election security, some of the main threats are, number one, issues of disruption of voting in the polling stations. On the election day, we have issues of disruption of voting, which of course hinders and impedes the right to free and fair elections. Yeah, we have issues of organized criminal gangs taking advantage of the election season. We have issues of criminal groups, or rather organized groups, being mobilized by politicians to bring about violence, to threaten the right to life and property. We have issues of election disputes. There's so many issues around election security threats, which now impede and hinder promotion of human rights and freedoms during the election season. And these are all issues that it is critical to have a discussion on, and to see what are the solutions, what are the recommendations from citizens, because we all have a role to play in promoting effective, fair and free elections, and to just have those conversations on how do we promote human rights during the election season. Thank you.
Yes, thank you, Lillian. And, I like everything you've said, especially the role in which the police play within the justice system, for example, and even some of the roles they play during elections, for example. So, Timothy, looking at this in terms of like the larger system, what would you say? What would you say about that system and how we look at governance from a larger perspective?
Okay, thank you very much. A bit loud. Would I have this volume reduced a little bit? Okay. Once again, good morning. As I had mentioned, my name is Timothy. I work with International Justice Mission, IJM. I think in the spirit of what my colleague has done, I'll start by introducing the organization and what we do. I know some of it might have been elaborated yesterday during the opening ceremony, but just take a few minutes for benefit of those of us who are not here. IJM is a global organization that works in 23 countries, and we have over 33 offices across these 23 countries in the entire globe. In a nutshell, what IJM does, we analyze and look at what we call everyday violence that happens within a certain jurisdiction or geographical area, and seek to address this everyday violence. What we have learned from our programming over the last 30 or so years, that everyday violence is not something that affects everyone. It is, to some extent, specific to those people living in poverty and those people who are poor. And what this everyday violence looks like is very different from one country to the other. When you go to a place like the Philippines, the everyday violence that the poor people in the Philippines have to deal with is issues of sex trafficking and child molestation. When you come to Uganda, here, our neighbors here in Kenya, the everyday violence that people have to deal with there is issues of widow disinheritance and violence against women. In our country, about 19 years ago, when a study was conducted, we realized that the poor communities in Kenya deal with a very specific violence that is everyday, but might not seemingly look as if it's an everyday thing to people, and that is police abuse of power, or what you call police misconduct. This was informed a lot by the people who are living in informal settlements, and you'd be very surprised to see that there's somebody in Mathare who is killed every single day. There's somebody living in a slum in Korogosho who wakes up every morning and they're not sure whether they're going to see the day because there's a chance that they may be murdered by the police. There's somebody living in some slum area somewhere far, and these are the everyday violences that keep happening. So we as IJM, and here in Kenya to be specific, deal with that as an everyday violence to the poor people living in our country. And we generally deal with the issues of police abuse of power. Just recently, we have also moved into the space of child sex trafficking, and we're doing that down at the coast. But because today is not a day of speaking about child sex trafficking, I'll speak about what we are here for, which is police abuse of power during, after, and probably before the elections. Police abuse of power, as I've mentioned, is not something that is new, as we have seen from the field that has been shown. It's something that happens, and they use the legitimate force that they've been given by the Constitution and by the legal framework and abuse it. What that looks like is very different. There are extrajudicial executions and killings. There is police inaction where police do not investigate cases. There are cases in which people are charged maliciously. As we've seen in that field, he was being coerced into coming to a confession so that he can have probably a free life or sentence. Yet, the alternative to that was for him facing charges for treason, yet they had nothing, absolutely nothing to do with that. And you'd find those cases are very many. That a young man in Mathare will be caught having done absolutely nothing apart from having dreadlocks on their head. Yeah? And one way or another, they find a charge that has been leveled against them, and they're appearing in court, and they're answering to something that they have no idea about, no clue about. Yet, it is a charge sheet, and there's a very high chance that they might be convicted and put behind bars for a very long time. What am I saying? The issue of violence against poor people by the police, it's a phenomenon that we have to grapple with every day, and worse off during elections period. I think all of us might remember during the last election cycle, I'll just pick up one case that was very specific. When a young toddler, 2 years old, fell victim of police abuse of power when they were shot, having done absolutely nothing, and she died. Bibi Pendo had not voted in that election, did not carry any placards to be against any politician, did not do absolutely anything that warranted that bullet that hit her. Yeah? And when you look at those things, it becomes very sad because there are things that happen on a daily basis, and there are things that we must also want and need to deal with on an everyday thing. And I think later on in the discussion, we'll look into it. What are the gaps and the areas that are there in terms of the legal framework, in terms of what do we need to do, in terms of all those things to try and see how that can happen. In a nutshell, I'll just explain how we as IJM deal with these issues. We deal with them in two fronts. Number one, cases of police abuse of power, police violence. We take up these cases and represent victims of police abuse of power, take the case through court and represent them as victims for us to be able to chase police accountability. While we're doing that, we look at the learnings that we're able to get from these cases and then take them back to the criminal justice system actors and tell them, look, while we were prosecuting this case, we found out that there's a gap in, one, the issue of investigations. There's a gap in, two, prosecutions. There's a gap in which adjudication is not being done well. And this is based on the evidence that we have been able to gather based on the cases that we have. And then what do? We take these learnings and tell them, from our experience, this is the way you can be able to improve the criminal justice system for it to be responsive effectively to the people that are in need of it. So we look at it from that facet that one, we are chasing accountability, and on the other hand, we're also trying to build that criminal justice system. Because if it was an issue of bashing the police every single day, and you're not finding a solution to the problem, then you're also part of the problem, for lack of a better word. So I think in a nutshell, that's what we've done, and I'm hoping we can have further discussions on it. Thank you.
Thank you, Timothy. I'll pass over to Clarice, and you can tell us from an international perspective, what are some of those gaps that you've seen in contrast to, let's say, other countries or regions?
Okay, thank you. Let me just start first by giving you a brief about the Office of the High Commissioner for Human Rights. So as you may well know that the UN is built on 3 pillars. There's the development pillar, there's peace and security, and then there's the human rights pillar. So basically the human rights pillar is what supports the other 2 pillars towards sustainable development and towards sustainable peace and security. So what we do is that we are the UN office mandated to work towards promotion and protection of human rights. So what we do at the global level is we set human rights standards in all spheres of life, be it in civil political arena, be it economic, social and cultural arena, and all the spheres that you can probably think of. At the national level then, what we do is we support national stakeholders, specifically government and other partners, to then integrate the international standards into their development agenda, into their programs, into everything that they do at the national level. So in Kenya, part of what we do is we support the government to integrate human rights into their Vision 2030, into the Big Five agenda, into their medium-term plans. We support them to report to human rights mechanisms, but on the flip side, we also work with rights holders. The beauty about what the office does is that we do not just focus on the duty bearers, the government, but we also work from the other side to ensure that the citizenry, that all the rights holders then enjoy their rights and are able to engage with the government to push for their rights. So bringing us back to the topic of discussions today, and as I was just looking at that film, really it spoke to a lot of the issues that I would want to raise today. And maybe what I would urge you, probably some of you are not born, when all this was happening at the Nyayo Torture Chambers. Maybe it would be good for you to take time, go and see Nyayo Torture Chambers. I went there when they were just opening it up to the public. And really, if you've been telling yourself that you do not want to vote, please go there and see. And maybe that will convince you on why you need to vote. So coming back to the topic, really, human rights is at the core of elections. Human rights is at the core of democracy. Human rights is at the core of governance. And really, the right to take part in public affairs is a global phenomenon. It can be found, at all the documentation, the instruments at the global level that binds all the states. You can find it in the Universal Declaration of Human Rights. You find it in the Covenant on Civil and Political Rights. But at the national level, you find that particular clause in our Constitution. If you look at Articles 38 and 81 of the Constitution of Kenya, it basically provides that every citizen has the right, without any discrimination, without unreasonable restrictions, to take part in the conduct of public affairs, to vote, and to be elected to government. Free and fair elections are those held periodically through universal and equal suffrage by secret, and the results of free political participation and the expression of the free will of the voters. So if you look at what that particular statement says, really it speaks a lot to the issues that happen behind the scenes during an election period. Because a lot of us think that election is just about going to cast the vote and then wait for results. Really, there's a lot that happens pre-election, during election, and post-election that has a great impact on democracy of the country. So basically, when you look at human rights in election, in the election agenda, it talks about the right to vote. But there's also the other side of it, the right to be voted for. I think many times we look at it from the perspective of, the right to vote, when we don't look at it as a right to be voted for and the right to vie in an electoral process. So basically what this means is that as a voter, I have my rights, to go and vote, but that other person who wants to be elected, who wants to be voted for, also has their own rights to take part in an electoral process and to be voted for. So really, genuine elections are necessary and fundamental component of an environment that protects and promotes human rights. So part of what we do in Kenya is really to look at the environment within which an electoral process is happening. When I was listening to IJM and Transparency International, probably, if I can say so, sometimes they come in when things have already happened, at the tail end of elections, when people have been arrested, police brutality has happened. But there's a lot that happens behind the scenes just before that. And a lot of it touches on the rights of citizens to take part in an elections. And some of the rights that we see being violated, and not just in Kenya, this is a global phenomenon, has to do with the right to be free from discrimination. And what do we mean by this? Sometimes discrimination is very subtle, that you may not really realize that you are being discriminated. And I'll give you an example from Kenya. If you come from a town or a city, that borders another country, maybe you come from Isebania, you come from Busia, it's not easy to get an ID, isn't it? You're subjected to another level of scrutiny. Unlike someone who comes I mean, I'm not saying that it's bad to come from a town near Nairobi. For example, if you come from Kiambu, you will not be subjected to another level of scrutiny. But if you come from Busia, you have to get a letter, I don't know from who, your grandfather's birth certificate, probably he died many years ago. But you're subjected to a different level from the level that other people are subjected to, which then means that it becomes very difficult for you to get an ID. And this, people who border Somali, people who come from the Somali community can tell you what happens to them, because even them, they're subjected to that other level of scrutiny. It means if you cannot get an ID easily, then you cannot register to vote, then you cannot take part in public, discourse, then it means you're disenfranchised. You're subjected to that level of discrimination. And one of the rights that you need for you to be able to take part in a genuine elections is to be free from discrimination. So really, the issue of issuance of IDs as a prerequisite to register as a voter is really a discriminatory element of elections. Sometimes we have others that really, as I said, sound very subtle, but they are discriminatory. When we have educational requirements, when we say that you must be a graduate for you to run, to run for a seat, it means if you did not complete school, you are locked out. Then we also say, the official languages in Kenya is Swahili and English. All documentation around elections is Swahili and English. If you do not speak Swahili and English, then chances are that you will be locked out of elections. In some countries, there's limitation to persons in custody. Luckily, in Kenya, civil society organizations went to court, and it was lifted, and people in custody can then vote. The right to freedom of opinion and expression. And really it links to that video that we were watching, that when you freely express yourself, when you have an opinion, then you're seen to be speaking against authority, you're seen to be speaking against the government. And when you limit this particular right, then you're limiting the right for people to take part in a genuine elections. right to freedom of association and peaceful assembly. And you'll notice that this happens quite often when we are in an election period, that when people demonstrate, they are arrested, and then they go through what IJM, police brutality and police, excesses. So when this right really is curtailed, then people cannot freely associate. That's when you see people are branded, you belong to this particular party, you belong to this particular party, you cannot come to this region is for this particular party. And I mean, you violate people's rights when you start, putting people in a box that if you belong to this party, you cannot campaign freely in this particular region. Peaceful assembly, that people cannot assemble peacefully, and raise issues, then it becomes a police issue, and the police then come in to address people in a not so peaceful manner. Freedom of movement, and then freedom from fear and intimidation. And you'll see that all these rights are so interlinked that when you violate these rights and you violate to take part in a free and genuine elections. So part of what we try to do as this office is to try to work with the relevant stakeholders to make sure that the environment is conducive for people to participate in a free and fair elections. The Constitution of Kenya in Article 10 talks about the right to participate, public participation. Yet when you violate all these other rights, then people are not able to participate fully in an elections. Of course, we understand that these rights do not operate in a vacuum. Sometimes they can be limited. But limitation of these rights has to happen, when there are specific and special reasons to derogate some of these rights. So we've seen situations where there's been restrictions in movements, especially when there's a state of emergency. We've seen people, like now there's conflict in some part of the country, and people have been contained through curfews. So curfews, really are a way to limit some of these rights, and it can only happen, when it's reasonably allowed. Then we've also seen some emergence of some issues that really curtail the freedoms that I've spoken about: freedom of opinion and expression, freedom of association, and peaceful assembly. We have issues around hate speech, where we have people spewing hate speech on social media, everywhere. You cannot speak because people then curtail your right to be able to freely express yourself and have an opinion. Then we also have fake news that has infiltrated our media, where sometimes it's very hard to differentiate between the real news and news that is fake. And this also limits some of the rights that are linked to human rights and elections. So what are some of the ways that as an office we try to support the government, we try to support civil society partners to mitigate these violations so that people can take part in a free and fair elections? So one of the ways is we work with national stakeholders to look at the legal policy and institutional measures that then allow for people to vote in a free and fair and timely manner. And we also try to work with the government to ensure that the legal reforms are done in a timely manner. I think one of the issues that we have seen in Kenya is that towards an election year, then, pieces of legislation are rushed through parliament, and there's no time, there's no enough public participation to ensure that human rights are integrated into those pieces of legislation. Gender concerns, issues for persons with disability are integrated into those pieces of legislation. So sometimes it looks like it's intentional to ensure that we rush through elections, and then a lot of the things that are put in those elections do not really sit in well with issues around human rights. Then also just supporting the election monitoring body, that's IEBC, working with the Office of the Registrar of Political Parties and working with the National Cohesion and Integration Commission, just to address issues that we've spoken about, the rights that lead to a free and fair elections. And then we also work with the relevant stakeholders, with the security sector, to ensure that issues around free speech, issues around opinions, assembly, demonstration are then allowed. I think one of the areas that we've seen, and probably my colleagues can speak more to it, is the use of the Public Order Management Act to ensure that people are not able to demonstrate in a free and, to demonstrate on issues that they feel are pertinent to them. Then also we support stakeholders to conduct civic education and voter education, so that we move away from the tribal, ethnic, and gender-based politics and move towards issue-based politics, even as people campaign. We also move to ensure that there's protection of special interest groups, women, persons with disability, and the marginalized communities to take part in the groups. Lastly, we also support election monitoring and observation. So apart from building capacity of relevant stakeholders, monitoring of elections is a key component of an electoral process. And you'll notice that during an election period, we have quite a number of monitors, international monitors, the EU, the Carter Foundation, the African Union, there's the ELOG group in Kenya who then monitors election. And this is because election is a cycle. It's not a one-off event, it's not an event, so it's a cycle. So the lessons that are learned from a particular elections are then taken forward to the next election to try and improve on some of the issues that were observed during the elections, and to try and address some of the violations that happened in an election year. Lastly, we also work with institutions that offer access to remedy to ensure that those who have been violated then have a way of seeking access to justice, either through the formal or any other institution that has been set up to look at elections. So in a nutshell, that's how we operate, but I look forward to having more discussions with you. Thank you.
Thank you, Clarice. Now I shall invite Amy from Amnesty International just to tell us about her work and the organization and the role they play in governance and human rights.
Okay. Hi, everyone. My name is Amy Ochiel, a human rights education and activism officer at Amnesty International. And Amnesty International basically is a membership organization that comprises of human rights defenders, just like me and you, who actually champion for the protection and promotion of human rights globally and even here nationally within Kenya. So currently we are really focusing on we have a campaign called Chambua Ngozini, where we look at political accountability based on the manifestos that are being given, and even what has the current regime been able to do in terms of realization of human rights. And also we have freedoms and citizenship, where we look at, during this particular period, we'll be doing a lot of monitoring of human rights violations and also the respect of human rights during this period. So we'll be doing that and working together with the human rights defenders across the country to ensure that there's basically protection and promotion of fundamental human rights during this period. So for us, I think even based on this topic, it's very fundamental to look at the gender-based bit on how human rights violations are perpetuated against women and minority groups during this particular time. And we have seen that during and even after elections, sexual violence has been used as a weapon of conflict to undermine women's participation during this particular time. And this not only happens within political parties, but it also happens even within the community. So that is something that we really need to be very vigilant about, even during this time, to ensure that we actually get minority groups and also women to be represented and to also experience fair and free elections during this time. And you'll find that most of the time, even when you base it on the 2007 elections, even till right now, the survivors of gender-based violence, and specifically sexual violence, till right now have not even received reparations for the kind of violence they went through. We still do not have police who were part of that particular group, if I may call, who perpetuated this form of violence against them, have not yet still been prosecuted. And this really plays a big role in making women not to actually take part in the general elections. And so as organizations, we really need to look into that so that we ensure that even as we are pushing for the 2/3 gender rule, we ensure that there is a conducive environment for representation for every person in their diversity so that they can have that free space to vie for the elections. And also another aspect that we really need to look into is a command responsibility. And this is where the superiors are actually held accountable for the actions of the police within the particular station. And this has been really lacking, and I hope, I don't know whether we've already developed a jurisprudence on this particular issue, but civil society are actually pushing for this to be one of the ways in which we can hold the police more accountable during the elections and even after elections. And most of the time we see the kind of violence that takes place because, especially after elections, because many people feel that it was not free, people feel it was not fair. And so you find mild protests are usually held across the country, and there are specific areas that are very targeted during this particular time. And so what happens? During this time, you'll find excessive force being used by law enforcement agencies in these particular areas. And the different forms of violence you get to see during this time will be the enforced disappearance, the tortures, unlawful arrest, and sexual violence. And so it is important for the government to actually come out publicly to acknowledge these particular forms of human rights violations that take place during this period, and even to ensure that the police who are involved in this are actually prosecuted and their victims are able to access justice, which is a constitutional right. I think also just adhering to, and even not even adhering, strengthening our early warning mechanisms is very important. This is to ensure that we are proactive in terms of protection of human rights as opposed to being reactive. Because most of the time there are you'll find even right now with the current use of social media, people will be there sharing videos on these particular trends that are happening within the community. And those actually play a very critical role in terms of early warning. And so this will really help to ensure that there is compliance of human rights. And as Amnesty, how do we ensure that these human rights are protected and promoted during elections? So first of all, we work together with stakeholders within the Missing Voices. Basically, the Missing Voices Coalition comprises of different organizations that monitor human rights violations, especially enforced disappearance, to ensure that we actually have accurate data in terms of people who have been subjected to enforced disappearance, and also just demanding for access to justice for the families that still do not know where their family members where their family members are currently. And also, as I had mentioned earlier, we will be doing a lot of monitoring across the country, also civic education, and also the aspect of safety and security for persons at risk, because that is also something that is really rampant during this particular period. There are many people who will be subjected to a lot of different forms of risks. So also we look into aspects of safety and security. And definitely we do not work in silos. We work even with the different partners here to ensure that we act in solidarity to ensure that the citizens are not subjected to any forms of human rights violations. Yes.
Thank you, Amy. Now I'll open this to the audience. Yes, so if anyone would want to ask a specific question, this is your moment.
Thank you so much. My name is Daniel. I have a question. So when we talk about human rights violations during, after and before elections, one of the things that we see is a lot of impunity, such that we don't see people being punished for either instigating violence or even participating in the violence. So my question is, what solutions would you give, either in the law or in our morality as leaders, as future prosecutors? What should we do so that we can ensure that the people who participate in these human rights violations, especially in violence, are punished and brought to book? Thank you.
Okay, I hope we're taking note as we go.
Good morning. So my question is more of a challenge to you. Don't you think that when we are talking of the role of police and police brutality, we've been having an exclusionary conversation in the sense that we rarely invite the police and have their view. It seems like we've already prejudged them, and therefore we work from a false basis, and that has led to a continuation of the problem, such that year in, year out, we are always talking of police brutality, may it be in elections, may it be in enforcement of government directives and such. And so therefore there's always been that problem. Maybe you can share your thoughts on that.
Okay, I'll take one more question, and then we respond to the initial 3 questions.
So my question is, in these cases, we are talking about police brutality. My specific question is, who is to blame? So do we go for the individual police officers? Do we go for the police department as a whole? Or do we go for the state? Because you'll understand policemen are state agents, so they are basically the state. So who do we blame?
Okay, thank you. So I think we can respond to the initial 3 questions, and then we shall proceed. Yeah.
What order you wanted us to proceed, but I'll just try and respond to some of the issues. I think the first question was on the issue of impunity, what to do. I think for me, how I would answer that question is that impunity is not even about lack of laws. It's not about lack of institutions or lack of policies. It's really more of the willingness to address some of these issues. Because in Kenya has been hailed as one of the countries that has the best laws. We have the Constitution, we have other laws, we have institutions, we have IPOA that deals with police brutality and police excesses. We have the Kenya National Commission on Human Rights that deals with issues around human rights. We have the Gender and Equality Commission, we have NCIC. So it's not for lack of having laws and policies, it's not for lack of having the relevant institutions. For me, it's more of the goodwill. Do we have goodwill? Because laws assume that there'll be goodwill. All laws assume that there'll be goodwill on the part of the duty bearers. It's just lack of goodwill. And for me, then it boils down to how do we as citizenry push for accountability? And one of the ways to push for accountability is just to go to an election and vote in people who then, are able to support issues of accountability. Police, who is to blame? And I think that's also linked to the next question of who should we hold accountable. And I'll just take you back, probably some of you are still young, but the ICC case, for those of you who followed it. And you'll remember that when the 6 were selected, from the police side, who was selected? Do you know who was selected to be prosecuted? Who was it? Hussein Aliyah. And what role was he playing? So really this speaks to the command responsibility. As you know, as the head of the police section, then he should take full responsibility, because it is under his watch that police are deployed to a certain region. It's under his watch that they decide, this team is going to maintain law and order in this specific space. And we know about how police respond to command and to authority. So really, the buck stops with the head of the police, because it is because of him there's omission to respect rule of law or commission to violate human rights. Then the other thing, someone asked about why do we then not bring the police into the conversation. I think a lot of the conversation is happening with the police, and the police do not just come into any space. Recently, they've started opening up, but they do not just come to any space. Fortunately, at the UN level, we are able to work with them because we support capacity building of the police. A lot of the police officers are not rogue police officers, but in every society you'll find elements of people who are rogue, and it is about dealing with those rogue policemen. In the last couple of months, the police have adopted a document that they're calling Standard Operating Procedures that is looking at issues around human rights violations. And if you see that document, it really shows goodwill on behalf of the police, on behalf of IPOA, on behalf of ODPP, and the Internal Affairs Unit of the police in an attempt to streamline issues around human rights within law enforcement. But still, we are dealing with a few elements, and for me, I think it's really about how the head of the police then takes up the role and ensures that those few elements are prosecuted and punished for the violations that they do. So for me, it's more about goodwill on behalf from the police side. Yeah.
Okay. I think I'll respond to two specific questions. Please. I didn't really get the first one. Thank you. I hope I'm audible enough. On the question of inviting the police into the conversation, I think, as has been correctly put by my colleague, they are part of the conversation and they ought to be part of the conversation. I think I agree with you, it would have been very beneficial if a team member from IPOA would have been part of this panel, and also somebody from the National Police Service would also have been part of this panel. But as my colleague said, they are part of the conversation, and she's referred to the SOPs that were developed in conjunction with the Office of the DPP, and it's important that once these things get rolled out, then as she said, when the goodwill is there, then the ability to work really follows closely. Allow me to take a bit of more time to respond to the question of who is to blame. Do we go for, I don't know who asked that question? Your name, sir? Makwata. Okay, Makwata, I really hope that you appear before me on Thursday or Friday during the Moot Court competition. Why I say that specifically, and I think I'm addressing it to all of you, that make sure that you have really read on that issue, because it will be a question that I'll be very specific on, and I will be expecting very serious answers, not just bare-bone answers. So this is just a caution before we begin and as you study. Make sure you look into that question, because I've looked at the compromise and it has very specific questions on that. Yeah? So make sure you study hard, because when I ask you a question, I'll expect an answer. And that is just on a light note. You asked a very good question. Who is to blame? Do we go for the individual? Do we go for the commander? Do we go for the inspector general, whoever it is? And I agree with you. My colleague has really mentioned, whoever is in charge of the command ought to take responsibility of it. And she mentioned about the principle of command responsibility that has now caught traction in Kenya, but has been an international principle for the longest time. A lot of the wars that have been propagated, not even just across the continent, but when you look through very specific wars in DRC, in internal wars across the continent, a lot of the commanders who appeared before the International Criminal Court actually appeared there based on the principle of command responsibility. And in a nutshell, what does that principle say? It says whoever was in charge of the operation as at the time the violence was being perpetrated, then that is the man that we should go for. What does that do? It ensures it's a disciplined force, and we all know the National Police Service is a disciplined force. What that means is that they act on orders. Yeah? Do this, do that. So when the person who is in charge is the one who's being put to account, then you can be very sure that if and when a situation like that appears again, then that person who is in charge might be, it's an assumption, be careful in the orders that they are giving. That's the first thing. In my opinion, it is not enough. Because over a period of time, there have issues that, what I call patterns and practice, that have been institutionalized within law enforcement that keep on going, whether or not there is a specific commander. That is why when today the officer in charge of a police station is moved to another station and there is violence in that area, there's a very big difference. There's no difference because whoever is in charge, there'll still be violence, though the person who's in charge has been removed from that station. It speaks towards a pattern and a practice within that needs to also be sorted out. When you look through pieces of legislation in the West, when you look at the Civil Rights Division, for example, in the US, which is an arm of the Attorney General's office that deals specifically with issues of human rights violations. And what they do, apart from looking for criminality in the violations that are happening, they also look at a section that is called patterns and practice. So what the Civil Rights Division has done, it has constituted in itself a body that looks into the patterns and practices of certain law enforcement agencies that speak towards human rights violations. A very good example. When George Floyd was killed in the US, apart from the officer that had been seen stepping on the neck of George Floyd, investigations were launched as to the police department where that officer had come from, to look into the patterns and practices that usually come out of that. What that happens is it deinstitutionalizes the human rights violations that have been institutionalized in some certain areas of law enforcement. I will not continue with that because I'll be giving you an answer to the question that I'll be asking, but I'll say it as that. It will not just enough to look at the principles of command responsibility at that level. What we also need to do is to get to the point where we are looking at the law enforcement in a manner that seeks to not just stop the violations short term or seek accountability for violations short term, but we're also looking at what is the long-term solution towards ending this violence. Is it an issue that in this certain station there is this problem? How can you be able to solve it? That, for example, you'll find that a certain law enforcement, maybe let's say the New York Police Department, is known for perpetuating some sort of violence over a period of time. So when the Patterns and Practice Office of the Civil Rights Division looks into it and makes specific recommendations, for example, that the entire unit be disbanded and everyone else is brought on board, that is a very huge blow on law enforcement, because when you're disbanding an entire unit of the police service, what you're doing, you're creating a problem that they need to reinstitute that, and it becomes very, so they'll be able to rethink more and more about the violations, because there is an impact not just to the individual officer, but also to the department as a whole. So I really hope we can look into that, read a lot of material on the Civil Rights Division and what we can be able to do in answering that question. But thank you very much for that question. It's a very elaborate question, and I hope our discussions can continue as we move on Friday. Thanks.
Sarah, if I may make a contribution. Yeah. So I'll respond to the first question by Daniel on accountability for persons who participate in violence. My colleagues have spoken a lot on command responsibility and the responsibility of the police. So we'll look at it from a different angle, and that is the responsibility of the leaders. So a lot of times we find that violence is instigated or fueled or condoned by leaders, and we find that actually political parties sign a political parties code of conduct, which they're supposed to enforce, and especially they commit to promote peace and to not condone any kind of violence as they conduct the activities. Now we also have, so that is the political parties code of conduct. Leaders also, or rather candidates, sign the electoral code of conduct. So these two codes of conduct are enforced by the Office of the Registrar of Political Parties and the IEBC respectively. So we find that the challenge is enforcement. So a lot of times there's an issue of leaders thriving on violence, thriving on intimidation of opponents, and the common factor in all this is really citizens allowing this kind of politics to happen, this kind of environment to be created, because I believe that if we stand up as citizens and not condone violence and promote peace, we will make a difference. We will not see those instances. But that is the current situation. The law is clear. There are mechanisms in place to promote peace really and fight against instances of violence. But enforcement is a challenge, and one of the main proponents or the key group of people who can actually promote peace is citizens themselves through holding leaders accountable, of course. Let me also talk about the social media aspect, because we're seeing a lot of tension fueled by social media or fueled through social media. And I find that there's accountability to some sense, since I do know that the DCI, which is one of the services within the National Police Service, is monitoring the social media space and trying to just hold people accountable for what they say through and the messages they promote through social media. Also on issues of hate speech, we've seen the National Cohesion and Integration Commission, NCIC Act, though of course there's an issue with the Act itself, and especially regarding admissibility of electronic evidence, because of course we find that in these instances where we're able to see violence come out, maybe in the campaign trail, in a meeting somewhere, it's normally a recorded video or something, and sometimes issues of admissibility of that electronic evidence, and I believe we are law students or lawyers, so we understand how such evidence is supposed to be presented. So unfortunately, we're seeing that the NCIC has not been effective in its role. We've not really had any conviction of anyone for issues of hate speech, so that remains a concern, and it is a conversation that we continue to engage in as an organization and other organizations on. How can we make the NCIC and all these other agencies effective to curb these issues we're facing around violations of human rights and violence within the election cycle? Are we unfairly blaming the police? Let me just say that the police are mandated to operate within the framework of the rule of law, and laws exist on how they're supposed to deal with situations. Okay? So there are laws on use of force, there are guidelines on public order management. They cannot just act as they want. So even in terms of use of force, excessive use of force is actually prohibited under the law. So even when they make a decision, when an officer makes a decision to use force, it has to be proportionate, number one. It has to be determined by the seriousness of the offense, by the reaction of the offender. There are those principles on how the police are supposed to use force. So those are the guiding principles. So in instances of police brutality, it is called police brutality because it has an aspect of abuse of their power, excessive use of their power. So that is the challenge. That is the reason why it comes down, the buck stops to the police, of course. And I will not touch on all those issues of command responsibility, but that is the main reason why I would say yes, when we have issues of police brutality, then we need to interrogate the conduct of the police, the commanders, and what informed their decisions. And of course, let me just say that police brutality really happens in the context of instances, a lot of instances, there's an aspect of infringement of the right to assemble, demonstrate, picket, and petition here. And the Public Order Management Act gives guidelines on what to do if you want to enforce Article 37, your right to peacefully assemble and picket and all that. So when you have infringement by the police, then it's of concern because the law, that is a constitutionally guaranteed right, which should not be infringed on.
Okay. Thank you. I'll pick.
Could I add?
Yes. Oh, yes, Amy.
On the aspect of who is to blame, I think we need to look at the systemic issues that currently exist within the police service, because as we know, it changed from being a force to a service. And so what exactly are the systemic issues within that particular organ of the government to ensure that we actually stop this police brutality? Because it is a pattern. Even during the colonial days, this was still happening. And the police have always been used to be a guard from governments so that we ensure that they lessen the level of accountability. And this, they use excessive force. And so this is what we have been seeing throughout during the colonial period till now. So that actually shows us that it's a systemic issue. Because even if the police officer is transferred to another place, we will find that they'll still continue perpetuating the human rights violations that we see. And I don't think it's only a Kenyan issue, because we are also seeing it within the United States, that there seems to be a systemic issue that needs to be addressed in order to put a human face during the operations of the police. So I think let's look at addressing more of the root cause, and also looking at at what manifests. There's something our lecturer in school always says: let us focus more on the root cause as opposed to the symptom of an issue. And I think throughout the dialogues we've been looking at the symptom, which the symptom is a police brutality and forced disappearance. But can we get to the systemic issues that actually enable and promote this particular forms of violence that we see we see the police perpetuating, so that we can actually realize the aspirations that led to them being called a service as opposed to being a force. And then on the matters of prosecution, as you know, justice begins at the investigation level. So if evidence is tampered with at that level, then we cannot actually prosecute the perpetrators. So it is very important for us to look at what exactly, how can we ensure that the evidence is not tampered with, because it's a criminal case and it has to be proven beyond reasonable doubt. So if the evidence is tampered with, and I think that is what even IPOA has been struggling with, because how do you go to the same police to ask them to investigate themselves? And even during the when the crimes are taking place, you'll find a lot of tampering with evidence, and yet when you go to court, you're being told it has to be beyond reasonable doubt. Again, the intimidation of the victims, because most of the time, matters of police brutality and forced disappearance also have very psychological effects on the victims. It also has psychological effects on even the witnesses themselves. So you'll find at that point there's a lot of fear, and even based on how do you go to, like for example, now the police are investigating, and also now you're being called to give your evidence, and you're still going to the same police. So you'll find a lot of intimidation actually takes place, and so again we find that the evidence is going to be tampered with. And so we really need to look at how then do we ensure we have the evidence itself, how do we ensure that there's cooperation between the different organs? And that also brings in the aspect of the goodwill that is critical in ensuring prosecution of the perpetrators. In terms of the dialogues, we have the Police Reforms Working Group that is in constant dialogues with the police to ensure we just bring these particular reforms that we are demanding for right now. And even when, I'll speak as Amnesty, when we do community activities and they entail matters of access to justice, we always invite police to be part of the conversations so that they can also listen to what the community is talking about. For example, in Nakuru, we had one of the police who is in charge of the gender desk being informed the kind of reception that the community receives when they go to report sexual violence. And so based on that particular dialogue, then the police and the community are able to understand each other. And it is very critical that they are involved, though they're quite difficult because of the protocols, but they have to be part of the conversation because the systemic issue is within their organ, so they cannot be outside the conversation.
Thank you. So I'll pick maybe 2-3 more questions.
Thank you very much. So I have 2 questions. The first question is, we are talking about the police and the way they met brutality to the people, but have we looked at the rights of the police? Because if I'm not wrong, last year but one, there was this, argument of the mental health of the police? Are we looking at it while actually blaming them for all this? What are we doing for the police so that they do that which they are supposed to do for us? And on to my second question on civic education. This is a room full of legal minds, and the education you're giving us is to help us in reaching out. But what of the people who are actually experiencing the police brutality? They have known it's a norm. They understand that every day when I wake up, I might not be able to sleep again. I will maybe sleep forever. They are used to it. How are they being reached out to? Are they getting the right education? Are they being told that this is wrong? Or do they feel that this is my life now?
Good morning. My name is Ian Lemayan from JKU Watt. I think my first question is closely linked to hers, and it largely touches on the welfare of police. Understanding the various surveys that have been done by IPOA, the understanding is that we, the citizens, understand that what the police are doing is wrong. But from the police standpoint, the police are understanding their actions from a position of authority, from a position of law. So most of the time they see us, the citizens, as the wrongdoers, and we, the citizens, see the police as the wrongdoers. So how do we strike that balance? That how do we take the information to them? How does the information reach the police so that they may be able to understand, because it is a historic problem, since it got from bad since independence to worse. Despite the reforms that we've been having, despite the reforms in the laws, reforms by IPOA, the problem still remains the same. So how do we check onto that issue that the police, they don't see the problem on their side, but with the people, from the outside we see the problems that they are doing. They think they're doing the right thing, but in real sense, that changes what I'd like you to explain. And on my second question, it largely relates on the role of police in elections. We largely see that elections are held. For example, the 2017, the incumbent was the person in power. He won the elections. And then there was demonstration all over. And the government, the incumbent, who was now the president-elect, was the one who was controlling the police. So how do we have any legal framework that prevents the police from being impartial in terms of elections? Because police have been with these people in power for the past 5 years. Now we have the next 5 years. They might not want the opposition to get into power because of the differences that they may have. So how do we prevent such biases by the government in power and people who want to get into power. Thank you.
One more.
Good morning, everyone. My name is Macharia Kamwero. I just have a question and a solution, perhaps. I have heard Madam talk about the rights of the police. And I believe, and this is my suggestion, that we really need to overhaul the curriculum and the training of the police officers. Back then when there was this case of George Floyd in America, one of the suggestions that came out strongly is to retrain these people. And I think that is when we're addressing the root cause of everything that's happening. We really need to check on what are we training these people to do before now they come out to the service, to the people. Now, my second question, and as the gentleman from IGM says, it's unfortunate that we don't have the IPO with us today. And those of us who live in Nairobi perhaps have had the opportunity to interact with them. But the problem with, and I'm not trying to criticize this, but I'm just to give the feedback, that the problem with all these groups that come to, try to help the victims is that they come perhaps when there is a public uproar of, what is happening. An example would be the Kenyan brothers. That it's after that there was a public outcry on the media that, Amnesty comes in, IPOA comes in, IAJ. I'm not trying to downpour, but I'm saying there's a need to perhaps have mechanisms in place to ensure that whenever something happens, because now, for example, right now in there's a video circulating on the internet of police officers killing 3 young men in cold blood. But unless that thing happens and it circulates over the media, we rarely see people happen. And if it does, then there's a question of, does the IPOA have the mechanism to handle these cases? Again, the criticism was that IPOA is a toothless dog, for lack of a better word. That they have, the laws are there, very good laws, but what is the mechanism to ensure that these people can work? Do they have independent analysts and officers and investigators? That is a question to ask. Grateful.
Sarah, allow me one more so that we have gender balance.
Thank you. I'm Akinyi. My question is on discrimination relating to right to participate in political affairs. Article 83 provides that persons of unsound mind are limited from registering to vote. And the same constitution provides that provides for universal suffrage, non-discrimination on grounds of disability and health status. So do you think the blanket provision on limiting persons with an unsound mind from participating in political affairs, taking into consideration that there are different degrees and levels of being of unsound mind, there's temporary, there's permanent. So do you think that the blanket provision for limiting them from participating from registering as voters is another form of limitation to right to vote? Thank you.
Sawa.
Oops. Yeah, can you hear me? Yes. So we'll just start with the first question, and that was looking at the rights of the police. And I think I'll address this to Timothy. Yes.
Okay, thank you very much. That question is very, my apologies. Really sorry about that. Very timely question, and it's important that, yes, as we're looking at what the police, what are they doing wrong, but are we also looking at what might they need for them to do the right thing? I think that's a question that came from the floor, and my response would be this. You asked a very specific question towards the mental health of these officers and what do we do about it? This manifests not just in violations against citizenry, but also we have seen it even against their own people. That a police officer wakes up and turns a gun on their fellow officer and shoots them and kills them. they're in a relationship with another officer, they wake up in the morning and they just shoot them. So it's not an issue that is just projected towards the public. It has now come to the point that it is actually even being projected within the service in itself, which now begs the question of the conversation around, do we need really to look at the mental issues and the mental health of police officers? And my answer will be a resounding yes. It is very important that we, not just as civil society, but the government invests in resources to ensure that the mental health of police officers is actually taken care of. And I'll give an example. Even you as a citizen, if you're exposed to these violations on a daily basis, it gets to you. And the trauma that either vicarious or direct that gets into you, it also gets to your head. So you can imagine a police officer who has every morning or every day has to pick up a body from this place. Somebody is brought to the station with a cut head and is bleeding, and it becomes very taxing. So as much as they're built towards ensuring that they are protectors, they're also as human as we are. And these things will, if they haven't gotten to them yet, definitely it will get to that point. So it's important that we have that conversation. What are we doing as IJM? We have very deliberate sessions with police officers and training on issues of trauma-informed care. That as much as you are taking care of people outside there, you also need to take care of yourself as an officer. There are things that happen on a daily basis and you deal with them as a police officer that might actually get to you. It's important that you have a session where you debrief, talk about these issues, get solutions to the problems that you're having. There's a very high chance that a trauma-informed police officer might not meet violations against citizenry as opposed to the other one who doesn't really have any form of redress or debrief within themselves for them to answer this issue. So the question that you asked, is it important? Yes, it's very important. It's important that we, as both civil society and even the government, put in place structures in which these police officers actually find a session to debrief so that they can let go and let off the steam that they have and understand that they are also humans and that they need to take care of themselves for them to take care of us better. I hope. Can I borrow your mic?
So looking at the second question on civic engagement, so how are we addressing reaching out to people who are actually experiencing police brutality? I think, Amy, you could answer this question in terms of, have there been any initiatives targeting participants or audiences?
Yes. So civil society is actually playing a critical role in terms of civic education on matters of police brutality, on matters of enforced disappearance, torture. And we go to the community and we actually carry out this civic education. And I would actually urge all of you as lawyers, actually more lawyers are needed on the ground to actually teach the community about the law. Because most of the time they say we just get to interact with the law at the police level or even at the court. But what now happens at the community is that most people's rights are being violated because they do not get the chance or do not even have access to the particular laws that you're talking about due to different dynamics. So we do carry out a lot of civic education. We also carry out a lot of inter-dialogues between the police and the community, and civil society is really playing a big role. So this information that this dialogue that we are having right now also takes place. And I would really urge you, even during your legal aids, during the different activities you have, consider having community engagements, especially at the informal settlements, also at the rural areas, to educate people on the law so that people can be more aware of their rights and also getting to know how they can access justice.
Thank you. So for the third question, so looking at the role of police in elections,
Are there any legal frameworks that could be used to prevent police from being impartial, and also an element on discrimination on the right to participate in election affairs? I think, Clarice, you can, yeah.
Thank you for those questions. Let me just tackle the one on discrimination first, where the person who asked the question was asking whether it's a blanket condemnation on persons of unsound mind. To be declared that you are of unsound mind is a medical process, yeah? No one can just wake up and decide you are of an unsound mind. So really the intention of that article was not to have a blanket condemnation, but there's a requirement that for you to declare someone of unsound mind, then you must go through a process where a doctor will declare someone of unsound mind. So really, it's not within the mandate of the electoral monitoring body to declare someone of an unsound mind. They must have proof that you are of an unsound mind before they can curtail. And really, to be declared of an unsound mind is really, a really technical process, because then it means that you cannot make a decision for yourself. If you are to be registered as a voter, someone has to be there registering you. Someone has to help you to decide even who to vote for. So it's not an easy thing to declare someone of an unsound mind and bar them from registering as a voter or even from voting. Role of police in elections. The IEBC Act says that in an election period, when the police are seconded to work with them to protect the integrity of the ballot, to protect the security of the votes, then the police transition from being in the police force to being part and parcel of the electoral monitoring body. So really they are under the command of the IEBC at that particular stage. And their role remains, to safeguard the ballot, but also to safeguard, the voters and people who are being voted in. So really it's about strengthening IEBC, because as we have heard, the police sector, the police agencies thrive on authority, command. Do they really respond to IEBC the same way they would respond to their own, authorities, the Inspector General, their structures? So really it's about strengthening the IEBC, or maybe even having, a specific, I don't know, this would, it's just my thoughts, maybe having a specific agency that is seconded fully to the electoral monitoring body, and they do not just come in during an electoral period. Because during an electoral period, even KWS comes on board, Kenya Forestry Service comes on board, and these are people who are seconded just for a particular period. So it becomes very difficult for IEBC then to have authority over them. But I just thought probably I could say something about the rights of the police, because I think this is something that as a country, and not just Kenya, many countries need to deal with the rights of police. Many times you will find that the police themselves go through a lot of violations as police officers. When you look at even the recruitment process of police officers, it's discriminatory, it's not done in a very proper way. And once they are recruited, you'll find that even the salaries that they are paid is so minimal. Housing. Police officers live in mabati houses, and those mabati houses are sometimes split with a curtain into four. Someone with their wife there, someone with another wife, someone, 4 families with children. Those are violations of the police officers. They don't even have medical, Then how do you expect them to go out there and protect the rights of people when their own rights are violated? So it means, as my colleague here was speaking, I was just thinking about, we really need to address the root cause of why the police behave the way they behave. There's been a lot of cosmetic surgery on the police, changing their name from force to service, changing their uniform to that light blue color, but really they've not addressed the systemic issues that that bedevil the police service. How many of you, if you're lost, you would ask a police officer for directions? I'm sure you would rather even ask a hawker on the street than ask a police officer. And this is something that hit me. At some point, our office is based in Geneva, and I had an issue with the police. The accommodation that I was staying in had an issue. And the police, they called me and they told me, oh, you have to come to the police station. The first thing on my mind was like, oh my God, I am traveling tomorrow in the morning. If I go to the police, it will take me another 2 weeks to be here to address the issue. I went to the police station. I couldn't believe, because it was such a friendly situation. The police was not even in uniform. He was a man who was in shorts and sneakers, and he offered me, a cup of tea. And one thing that he said really stuck to me. He told me, do not worry, our police officers are not like the ones you have in Kenya. That really shook me, that we are known all over how our police behave. He told me, no, here we just want to get the record straight, you're free to go. They even dropped me off back to my hotel and offered to drop me off at the airport. I know we are not yet there, where the police can drop you, but the public perception, the public perception that we have of the police is that I cannot even ask this police a question. The next thing, bangi will be planted on me, the next thing, the police will arrest me for, I don't know, doing something. So really, it's also upon us as the society to help with this transformation, because it is the citizenry that can build confidence in the police, that we trust you as the police, that for us to trust you, do 1, 2, 3, 4. Have dialogues with us, then we are able to trust you. But I think really we must address the systemic issues that bedevil the police force if we are to see change that is not just cosmetic change, uniform, and all that. Thank you.
So for our last question, yes, how do we strike a balance between information sharing and particularly how do we reach the police? So I'll address this to Lillian.
All right. I think that was a question by Ian on the disconnect between what citizens believe and what the police believe and all that. I will just say it again, and we've spoken about it here. Training, number one, there's an issue with the training of police, and we have to really look at the curriculum and interrogate really the curriculum, even from a human rights-based lens, and just ensure that there's a linkage between what the police are being trained in colleges and also now the reality out here. Again, like issues of ICT, and I know they have really actually made advancements and changes to the police curriculum, but this needs to be continuous, of course, to really just look at the curriculum and determine what needs to be, what kind of training is being given to the police, and even the refresher courses and all that. One of the mechanisms we have used as Transparency International is police dialogues, which we normally have on anti-corruption. Of course, we know that, I don't know if you have seen our corruption perception indexes, and the police always top the list of the most corrupt institution in the country. So we've been able to just engage with them directly, go to their level, and not just the commanders, the people at vigilance, but just talk to officers and understand what are the reasons, what are the causes, what are the challenges, and to even have them give us solutions to corruption within the service, because they know the challenges and they know the solutions. So we've seen that dialogues and ongoing dialogues with the police yields results, because they're able to now understand them, because it does not help to accuse them, but not also now hear from them and understand what are their issues. So continuously, even to build that linkage and to avoid that disconnect between the police and the public, it's important to just continue having dialogues facilitated by the NPS themselves, government agencies, civil society, to have that kind of discussion. Let me also talk about the community policing, which is now under the National Police Service Act. So we have community policing, which is supposed to be an avenue where the police in the community or the public can engage, collaborate on matters of law enforcement. So these channels are envisioned to be a place where it will be possible to connect the police to the public and also the public to the police and understand each other. We'll find that a lot of times when a community has a police station within their space in that community, they do not see those people as members of the community. Yet the police are a critical player or part in matters of community affairs, right? Policing with binadamu. So they're also members of that community, and just to reinforce the notion that it is important to engage with the police, and even for the police to understand the public and to see them as humans and people who need their services, because policing is a service that it is offered to the public. So should not be from the lens of a favor, authority, and all that. It's a service that is being given to the people. So that's important to have that kind of interactions really with the police to ensure that we entrench positive relations with the police, and even to address some of now the symptoms we're seeing of a service that is not in touch with the people, that is not in touch with human rights standards and all that. Let me also add on the mental health issue. One of the conversations we're having is that the importance of, even during recruitment, to look at who is being recruited into the service. The people who, a lot of times the recruitment process of the police is focused on physical attributes, but it's important to also look at other attributes, including mental health and all that, even as they get into the service, as people get into the service. I think in the Kenyan context, a lot of times the people who go to the police service, and you'll find that in some instances, you hear people say, a member of our family is wayward, anafaa pelekwe polisi, ama anatumia XXX. He's just someone in the community, but now people want to take that person to the station. Again, issues of mental health, really, even before you join the station, and these are things that the National Police Service Commission should be looking at as they undertake the recruitment, to just, even from the initial point of entry into the service, are you suitable to join the service, and just even considering the requirements of the service and what you're getting into, are you able to handle that? So that's a very important conversation that is ongoing, and we need to continue having those discussions on mental health.
Sarah, I think there's a question asked on the public outcry.
Yeah.
And in terms, and specifically, I think one of us mentioned concerning the Kiandrakoma brothers issue. I would say that, yes, there is usually the public outcry, but if you actually go to civil society organizations, you'll be struck by how many cases we handle per day. And so you'll find that there are some that will actually become a public outcry, but they're actually, I will say they're the few that you see. Most of the time, civil society organizations receive a lot of cases that we always channel it to the police, again, to investigate, and also include other organs such as the ODPP and the DCI to also help to ensure that the victims access justice. And you will find that this is usually not an easy process, because civil society does not have a judicial or an investigative role. So we'll again solely rely on the police and the courts to help us to ensure that the victims are able to access justice. And many, if you even went right now to TI that has the legal aid bit, you'll be surprised in the number of cases. Even us ourselves, when we receive cases, for example, enforced disappearance through the Missing Voices Coalition, there are so many cases that are still within the investigative stage or even at the court stage. So it's usually very few cases. Actually, those are the few ones that you get to see within the media. Majority of them have already been reported. So it's not more of being reactive to the trending crimes. It's those, there are many that are still being investigated. So many of them have already been taken to court. And the lawyers within the civil, or the advocates within the civil society organizations really help the victims to follow through the cases and to ensure that there is access to justice, and even to ensure there is no tampering with the evidence. Yeah.
Can I just add something, little, just to what she said? I think it's true. There's a lot of work that is going on, and I think maybe it's a challenge to all of us. Maybe we need to amplify a lot the work that we are doing so that people know, because there's a lot that is going on in the background. It might not come out in the public. It might seem as if we are reacting, but there's a very high chance that we were there at that time, just immediately after it happened, but it came out in the light shortly after. So it's important, and I think it's a challenge to all of us who are seated here and as civil society, that the more we amplify the work that we do, the more people understand, not just us also, IPOA, IAU, because there's a lot that is going on. They're not just seated somewhere. So it's important that that conversation keeps going. Thank you.
Okay, thank you so much. A lot of interesting conversations coming up, but for the sake of time, I think we'd like to wrap this up. Yes, but feel free to engage with the panelists, ask more questions, and see where this goes. So thank you so much. With this, I'd like to end this and pass this back to the host organization. Yes, thank you.
Thank you so much. Let us clap for our panelists. And not forgetting our moderator. Let us clap for her. Now we're proceeding for our tea break. So all students will proceed to the other side of the school at U0. We have prepared tea. So first our guests will leave, where they will be escorted to first floor. They'll have their tea there. Then the rest of us, we go to U0. Thank you so much. Let us proceed to U0 for in the interest of time. So it's 11, so we give you 30 minutes. So 11:30, we come back for our next session. Thank you so much. and physical conference. This is a good thing. My task is very simple, to introduce the panelists before you. Is Mr. Ochel Dudley. He is the Litigation and Research Counsel at Katiba Institute. Next to him is Derek Mahandia, who is a Program Officer, Policy, Legal and Institutional Frameworks, Transparency International. Next to him, two things I'll say about Timothy. One, his current is an attorney at the International Justice Mission, and he's also the person that handed over the presidency to me at the All Kenyan Moot Court competition. So it's good to see him giving back. He was the president in 2018. So it's good to see the alumni coming back to feed into the competition. So I hope that even as you participate in this conference, after you leave your schools, you will still come back and help All Kenyan be what it is today. The topic of discussion today is analyzing the administrative gaps, legal gaps, and ethical concerns that result in electoral malpractices. And we will seek to explore as wide as possible the landscape on structural as they may be, or any gaps in the law or policies that exist in our electoral law jurisprudence, and how that has then affected or helped curb electoral malpractices. And the panelists will have 7 minutes to share with you their preliminary remarks. I will ask a few questions, and then we will do a plenary where we'll receive questions from whoever has a question from the participants. So the first on the list will be Ochel Dudley, who will begin us off, and then they will continue like that in the order of introduction. Karibu sana.
Good morning. It's my pleasure to be with you this morning, and we'll briefly consider the issue of standard of proof in election petitions. If you've gone through your evidence classes, you know that there are how many standards of proof? How many? How many? 2. Beyond reasonable doubt and on a balance of probabilities. Which one do we apply in civil proceedings? Beyond reasonable, balance of probabilities. Beyond reasonable doubt is left for criminal cases. Now, when we first had our Elections Act, the current Elections Act, there was a Section 87. That section stated that if an election court finds that an offense has been committed, then it would make a report to the IEBC and to the DPP, establishes that an offense has been committed. Because of the wording of that section, the Supreme Court in Raila 2013, held that if you allege a criminal offense in a petition, then the standard is intermediate. The standard is beyond reasonable doubt. But then in other cases, it's intermediate, in between balance of probabilities and beyond reasonable doubt. It made sense then because the Act says that if the court establishes that an offense has been committed, then the court will make the report, and there were consequences, including the candidate being disqualified. Now that section was deleted in 2016 by the Electoral Offences Act. It was part of those changes made in 2016 to the elections law. So in 2017, Raila told the court that the court was wrong in 2013 because, one, there are just two standards of proof, no in between. It's either balance of probabilities or beyond reasonable doubt. So he asked the Supreme Court to reverse itself. The court refused and asserted once more that the standard of proof in election petitions in Kenya is intermediate, not as high as beyond reasonable doubt, but higher than balance of probabilities unless an election offense is alleged. That holding of the Supreme Court had no basis because the section that said that an election court could establish election offenses had been deleted, and the law is now different. You now have another Election Offences Act. Under the Election Offences Act, the DPP has 2 years to prosecute someone. That would obviously go to the magistrate's court because elections are determined within 6 months. So if the DPP has 2 years, obviously these 2 years go beyond the 6 months, don't they? They do. So that trial would take place in a criminal court. And there we agree the standard would be beyond reasonable doubt because it's a criminal case. However, recently the Chief Justice Maraga, who was on the Raila 2017 bench and who led the Supreme Court in reiterating that where you allege an electoral offense, then the standard is beyond reasonable doubt, has had a change of mind. He has now said that that standard the Supreme Court set has no basis. So I'll just try to explain why I think he is right on his change of mind and why the standard of proof in election petitions in Kenya is not beyond reasonable doubt, but is on a balance of probabilities. In 2013, the Supreme Court relied on case law from Malaysia, England, Ghana. In England, the Act uses the word guilty. If an election court finds someone guilty of an election offense, then the court can sentence him. That means that electoral proceedings in England are quasi-criminal. They have a criminal element leading to a finding of guilt. We don't have that anymore. In fact, Section 97 has been stripped down. The only offense remaining in it is the offense of double registration as a voter. No one is likely to raise double registration as a voter as a ground of a petition, that a voter registered twice. It would have no relation to the election petition, so it's unlikely to be raised there. So everything else would go to the criminal court in a criminal proceeding under the Election Offences Act. But the Supreme Court did not consider that difference between the law in England and the Kenyan statute. The Kenyan statute now has no that. In fact, it now says that the court may find if the court may make a finding that an election offense may have occurred, could have occurred. What's closer to could have occurred than balance of probabilities? It's not beyond reasonable doubt. You don't need proof beyond reasonable doubt that something could have happened. It's called preponderance of evidence, likely to have happened, more likely than not, balance of probabilities. So in 2017, the court was wrong in insisting that the standard of proof in election petitions is beyond reasonable doubt. it didn't consider or even mention Section 87, even once. In 2017, it did not consider the amendments that had happened, and that now we have another law dealing with election offenses, and it's no longer under Section 87. And it also didn't consider the language of the UK Act. We consider that constitutional borrowing is valid, but the court should consider the context, because a word in a statute may have an entirely different meaning. The word guilty in the UK, it's the Representation of People's Act, means that those proceedings are quasi-criminal. In Kenya, they're just civil proceedings. The other reason is this, why we agree with Maraga on his change of heart. Under the Constitution, things like torture, cruel and degrading treatment or inhuman treatment, or any other constitutional violation doesn't require proof beyond reasonable doubt. It is not required anywhere else. Now, elections flow from Article 81. So why should we have a different standard of proof for elections which does not apply to any other constitutional violation? And these are as an effect on the quality of elections, because it imposes an undue burden on the petitioner for you to prove beyond reasonable doubt that an electoral violation occurred within the 6 months that election petitions run. The DPP, remember, under the Election Offences Act, has 2 years to prove something that you must prove within 6 months. And for presidential elections, it's 14 days. They're had within 14 days. So you have 14 days to prove beyond reasonable doubt something that the DPP has 2 years to prove. It's unequal, it's inequitable, and it is not right. And so that's why we agree with Maraga on his change of heart, and we make the case that insisting on that standard of proof beyond reasonable doubt for election petitions leads to electoral malpractices that the court could have stopped going unpunished. Because the petitioner would be unable to prove them. Thank you. I'm sorry for overshooting my time. I think I have a few minutes. Thank you.
Thank you. Thank you very much. We will listen to Mr. Mahandi next.
Good afternoon. I'm also equally happy to be here. I'm not an alumni, and I'm alumni of Moi University. That was many years ago. Those times you were better than you, but I think you've really caught up. Today I'm going to talk about two things. One, and still following on Otiel's footsteps on standards, but I'm going to talk about standards of ethics, standards for leadership and integrity in the Constitution. And then after that, I'll talk briefly about election campaign financing. So when you look at if you look at our Constitution, it has been said that it is one of the most progressive constitutions in the world. And part of the reasons why it is so is because there are certain values that are in the Constitution that do not necessarily define governments or structures of government. If you look at values such as, they really define how people in public office interact with power and the people they serve. If you look at Article 10 of the Constitution, it talks about values such as patriotism that should guide any public officer in carrying out their duties. Patriotism, human dignity, good governance, integrity. So these are values that are a bit traditional way of measuring how patriotic someone is neither criminal nor civil. But the Constitution seems to talk about some values that need to be met. If you go further under Chapter 6, it talks about public trust, respect to the people, and it requires public officers to conduct themselves in a manner that brings honor to the nation and dignity to the office. It also talks about public officers must carry themselves in a manner that promotes public confidence in the integrity of the office and power to serve rather than to rule. So what do you think about these values? What do they ring in your mind? Is it criminal or is it something else? If you go further, Article 73 talks about personal integrity of our leaders, objectivity, self-service in carrying out these services. And then Article 75, and sorry if I'm taking you too fast, tell me to slow down. Article 75 talks about requires public officers to behave in a manner, whether in public, private, or official functions, in a manner that does not demean the office of the office holder. So if you subject yourself to public office, then you should be aware that the Constitution requires us to scrutinize you even whatever you do in your bedroom or outside. That is what the Constitution says. It's not our saying. So clearly, there seems to be a very high threshold that is put on public office. So after we pass this Constitution, in fact, the Constitution has an entire chapter on leadership and integrity. That was in 2010 when we passed this Constitution. In the elections, because these are standards that everyone is required to meet, we would expect that before you are cleared for public office, you have to meet certain ethical and moral standards. And that is also a provision of Article 99 of the Constitution. So there has to be a clearing mechanism which sieves out people who do not meet these standards. Are we together? And are we in agreement? Are we in agreement? Yes. So we have, that is an irreducible minimum. So coming to the first elections under this Constitution, we have people who we believe do not meet this standard. And there is a case that is taken to court against our current president and deputy president. And the petitioners are arguing in court that these gentlemen, because they have a case in the ICC on gross human rights violations, and all those things of post-election violence, these people do not meet an ethical and moral standard. But interestingly, the court does not agree with the petitioners. And the court sets a standard. And it says, for you to be barred from contesting office based on Chapter 6, you must have been, it uses the test of innocent until proven guilty. And the court relies on Article 99.3 solely for that conclusion. Article 99.3 says that you are not disqualified from contesting for office and from being declared unfit to hold office on leadership on ethical and moral grounds unless you've been convicted and all avenues of appeal have been exhausted. But what is conviction? Conviction is an end to something, which is a criminal trial. Are we together? So the court introduces a criminal standard for ethical and moral issues, which we had an issue with. So sometime later, in 2012, so that is now a criminal standard that the court has said, unless you've been proven guilty. But that is a criminal standard, not an ethical one, and which we depart from the judgment of the court. A few years later, in 2012, something interesting happens to our then Deputy Chief Justice. I think you remember her. She was called Nancy Baraza, and she was removed from office. What did she do? In fact, it was not even slapping. It was pinching a nose. Yes? We are together. And we remember she was removed from office for that. And the JSC say that, relied on the same constitution and say that the standard for holding office is so high. You have to be like Caesar's wife. It has to be beyond reproach. So we cannot wait for this criminal trial to end for us to remove you from office, because that is not our standard. So, she went to court, but the court upheld the decision of the JSC. So what are we seeing? A shift in the standard. So the court no longer says no. It's something different. So sometime later, when we have these governors into office, before even then, we remember the case of Swazuri. He was the chair of, was it the chair or the CEO of National Lands Commission? And there was a time, there were charges against him, corruption charges, and the court asked him to step aside from office pending investigation. But what his defense team were arguing, that these bail terms are so punitive that they sort of infer some criminal culpability to the accused person. But he is innocent until proven guilty. So if you tell someone, do not get into office because there are charges against you and you might interfere with the witness, then basically you are sort of saying that, no, we are doubting you. So it's no longer innocent until proven guilty for public office. And the court asked him to step aside. And that was the same judgment later on applied to Ferdinand Waititu, Mike Sonko, and Moses Lenol Kulal. The courts have asked these people to step aside, not continuing holding office, even though they are pending case. So there are certain liberties that have been suspended from them. So what the court seems to be talking is it's setting a different threshold for public office. It is no longer innocent until proven guilty. There's something different. Now, there's another case I forgot, something which is tied to what Dudley presented. In 2012, I think it was 2013, my good senator, Moses Wetangula, had a case in court. So he was contesting against Mohisa Kitui. It was Musikari Kombo. So there was a case, there was an election petition in court, and the courts, all the way to the Supreme Court, nullified the results of the elections on grounds that Wetangula had committed electoral malpractices. So it nullifies the electoral results and orders for fresh elections. So in the fresh elections, the petitioner, in the next elections, the petitioner comes and says, this gentleman was found by the Supreme Court to have committed electoral malpractices. So he does not meet this standard of Chapter 6. Let him be barred from contesting for office. But then the court takes an about turn and says, no, because he was not tried in a criminal court, and Article 99.3 says you cannot be barred unless you've been found guilty, we will not debar him. But the earlier court had told the DPP to do investigations and press charges, but it did not. So here we see there's an issue here. There's a standard which is being referred and relied upon by clearing and vetting agencies, that is IBC and ESCC, which is criminal. But the Constitution obviously talks about other standards. You can be removed from office for gross misconduct. What does that mean? Does it mean you will be taken to court and found guilty? You can be removed from office for gross violation of a constitutional provision, including ethical values. So our position is that you can be morally and ethically unfit, but at the same time, you can fail to have a criminal case against you. And that is what we are pursuing these elections. We've already gone to court. We are trying to convince the court that there is actually a standard which you guys have misapplied. And EACC and IBC have not applied properly. And if you apply this standard properly, you would see people with pending corruption cases stopped from contesting, not being cleared for office. You would see people with criminal cases in court causing grievous bodily harm. I mean, if surely you take out a gun and shoot someone, you shouldn't be cleared for contesting office. We don't have to find you guilty because our processes also take a lot of time. If you've been found to have committed election malpractices and the court has used that action to nullify an election, then we can't clear you to contest another one, even if you've not been charged. If you've committed, like the Nancy Baraza case, if you conduct yourself in public, in office, in a manner that does not promote confidence in that office, then you shouldn't be cleared. And also, if you've been adversely mentioned in a report by a fact-finding body, then you should be barred from contesting office. And we've seen some of these people who are found, who are morally lost, getting re-elected and continuing to perpetrate these vices. So that is one of the things we are pushing. The other thing, and I'll be very brief on this one, is on election campaign financing. We all know that elections are very expensive in this country, and there is a tie, a link between corruption scandals and elections. Goldenberg was used to support the first and second multi-party elections in this country. We've seen some of Anglo-leasing the 2007 elections. We are seeing some of the NYS suspects now wanting to contest for office and use some of those monies. So the Constitution says IBC, the Constitution requires IBC under Article 88(4) to regulate the amounts of money that is used during campaigns. But since we implemented the new Constitution, we have not had any regulations in place that regulate how much we use during elections. What IBC has been doing is that they have been doing draft regulations, sending them to Parliament, and waiting for Parliament to approve them. But Parliament, since 2010, has been rejecting all regulations. And it goes without saying that it doesn't make sense to regulate yourself. How can Parliament regulate how much money it is using in elections? So we have gone to court together with Katiba, and our argument is that IBC has the primary mandate to regulate campaign financing, and that mandate cannot be shared. It should not go to Parliament to seek approval for these regulations. These regulations are what we call constitutional instruments. They should be enforced by the mere action of IBC gazetting them. So we hope that we will also be able to achieve this. We are going to closely monitor the elections to see how much money is being spent and where it is coming from. Thank you very much.
Thank you very much. Mr. Timothy will take the floor.
Good afternoon, everyone, once again. I think in the spirit of my two seniors standing up, I think I'll take the floor. The question at hand is one that is multifaceted, if I may put it that way. And the two speakers who were here before me really spoke in depth and at length on the issues that really affect, or what are the contributing factors that actually attribute to electoral malpractices. Not just that, but also what really prevents effective adjudication of these electoral malpractices cases within our criminal justice system because of the policy gaps, or rather because of the gaps that are there existing both administratively and also legally. My sole responsibility will be to look at another angle of these electoral malpractices that might not really come out in the conversations, especially when we are talking about issues that are to be dealt with at the Supreme Court level in terms of election petitions. And I'll keep referring to the document that you'll be using, a majority of you, when you're coming for the moot court on Thursday and Friday. That you're faced with a situation whereby there are gross human rights violations, among other things, that you're required to prosecute before the Supreme Court. Yet, the Constitution in itself and the article that gives life to the Supreme Court has specifically set the parameters in which some of these cases can actually be brought before the Supreme Court. So it's a matter of jurisdiction. Does the Supreme Court have jurisdiction to deal with these issues, and at what level does that have? I'd wish to adopt the submissions of my seniors here regarding what are these policy gaps that are there, and what are they, how do they exist, and what are the dynamics at play. They've mentioned about the standard of proof that is required in both ethical and also at the level of civil cases, that it is being used, the criminal standard of proof is the one that is being used to determine such cases, and it has really brought a lot of issues. From where I sit and from my view, a lot of the issues on electoral malpractices, I think from the panel session that we had before, really stem from an issue that is more systemic than an any day or everyday event. And why do I say this? The speakers before me have alluded to two things. Number one, that we as the electorate, and also the citizenry at large, do not have confidence in the criminal justice system or the justice system in itself for it to be able to address issues of electoral malpractices. That's the first thing. The second thing is the confidence that is required by the electorate for us to ensure that once a petition has been filed in court, either a petition has been filed in court or criminal charges have been preferred in court, then there is that assurance that you're sure that this matter will and should be adjudicated in a very quick manner. I'll give a reference to the Supreme Court petition and the regulation that mandates, the provision that mandates the Supreme Court to hear and determine matters of election petitions regarding the presidency within 14 days. That means the Supreme Court and the petitioners all have 14 days to which they will present their case in court. The court will hear, analyze, and determine and give a verdict within that time, 14 days. The speaker before me mentioned that in instances where there are electoral malpractices, the DPP has 2 years to be able to ensure that they have brought up a case and brought it before. Yet petitioners are being given 14 days to ensure that this has been completed. My argument is this, and I really support what that would look like in terms of, yes, that time and the standard of proof that is required really does not help in ensuring that electoral malpractices have been finished. However, we are faced with a situation where we are where we are. Yeah? The Constitution has given a provision that within 14 days, these matters must have been concluded. Yet, you will find in the criminal justice system today, and I'll make reference to the criminal justice system because that's where I practice, a lot of the cases, as trivial as drunk and disorderly, as trivial as what used to be loitering with intent, I don't know whether it's still in the law, and such kind of cases would take 2-3 years before they had and determined. Because the person who will be arraigned in court will stand up and say, Your Honor, ni ukweli ya kwamba nilishikwa nikifanya hivi, lakini, and for you students who are here, you know, once you put in that lakini, it becomes a plea of not guilty. Yeah? So you enter the system and you're processed for a very long time. They mentioned that a lot of the cases that we have really take such a long time before they can be concluded in court that even we as a citizenry do not have any confidence into that criminal justice system. Because I know if I take this case, the longest or shortest time that it can take is a very long time. cases that even involve children, that by best practice require to at least take not more than 6 months, are taking 3 or 4 years. And we as a citizenry have lost confidence in the criminal justice system because we do not believe that when we go to it, it's going to respond to our issues. How does that relate to the issues of electoral malpractices? A lot of the violations that come along, other than the standard on what voter bribery and many other electoral malpractices that ideally would find themselves in the flow of an election petition court, really come from a point of the users taking advantage of what the system is for them to move to a space where they can do whatever they want. And this is why I say this. In 2017, Baby Pendo was murdered in cold blood by what has now been reported by police officers who are trying to quell a demonstration on the lakeside of this country. Up until today, and somebody might correct me if I'm not wrong, there's no one who has faced a charge of either murder or, as we were talking in the morning, on command responsibility regarding this. We are now going into another election cycle where there is a chance, and I say this, there is a chance that there will be a lot of gross human rights violations that are going to come out at that time. Yet, from the previous cycle of elections, there are some that are yet to be sorted. Why am I saying this? For us to have confidence in the criminal justice system to handle these issues, then the criminal justice system must provide us with that confidence. That we must look to the courts for us to know that when these issues are heard and determined as quickly as possible, then we can be sure that even these cases of gross violations that go to the court, especially during election time, are going to also be heard and determined as quickly as possible. The standard of proof might not be changed because it's a criminal matter. It's beyond reasonable doubt. That's not an issue. You must actually prove beyond reasonable doubt that actually a criminal offense occurred. However, if the time taken for these cases to be concluded, one, not just to be concluded for the sake of time, but also in a manner that is just to the litigants, then it has to be a process in which a lot of ongoings really really go into the process of ensuring that these cases are completed. That is the first thing. The second limb would be these cases, making reference to the case that I had mentioned earlier, cases of drunk and disorderly, cases of very petty offenses, if I may call that. A lot of these cases have really clogged our system in the event that some of the more serious cases that ideally the state would want to spend a lot of resources on, the court does not, the judiciary does not give the time and resources allocated to it. Because when a magistrate comes to court in the morning, there are 25 mentions. Of the 25, 20 are on drunk and disorderly. The rest are on very minor and petty offenses. So if the court starts at 9, by the time it's dispensing off its cases by the time it's around 11 or 12 p.m., then the magistrate is already tired. There are 6 other matters that have been listed for hearing as at the time they're supposed to begin. That is where you hear the magistrate will say, I'd like us to take an adjournment, or even the prosecutor who was not ready will say, I'd like us to take an adjournment, because they've already been drained so much, but there's so many cases that are within the criminal justice system that are undeserving. As I conclude, and this is my thinking, and this is my thought, if we get to a point where the number of cases that go into the criminal justice system have been filtered to the level that what is going into the criminal justice system is those deserving cases in which the judiciary can spend time and resources to be able to conclude on them, then there's a very high chance that we'll have improved our confidence in the criminal justice system to the extent that any matter that stems from any malpractice, be it an electoral issue, be it across the board, it will be heard and concluded in a timely manner. What the DPP has done currently, they have issued what we call the decision to charge guidelines. The decision to charge guidelines are meant to guide the prosecutors in ensuring that the cases that are going into the criminal justice system are cases that are well deserving. What does that mean? There is a standard in which, before the DPP accepts to charge an accused person, they have analyzed several things. Number one, is there enough evidence to be able to sustain this charge? Number two, is it in public interest that this matter be brought before the criminal justice system? And in some extents, is there an alternative to prosecution? Once they're able to look at these three things, then they're able to filter out so many of the undeserving cases that go into the criminal justice system and give the justice system enough time to process issues that might, in ordinary sense, take a long time to be processed. What does that do? It frees up the hands of the judiciary and the criminal justice system from dealing with all cases of whatever case that you might bring, and put on more time and resources to be able to ensure that the deserving cases are able to go through the criminal justice system. In turn, what does this do? It builds the confidence in the criminal justice system, and as my colleagues have said, in the event that we are able to reduce the time in which, or rather increase the time in which election petitions might be heard, or reduce the standard of proof for which these cases can, but we're able to, on this other end, reduce the number of times, or rather the amount of time that the criminal justice system takes to process these cases. And in essence, we're going to improve it gradually. And I say that because when we're looking at alternatives to what the solutions will be to the problems that we have, we must look at it in a multifaceted way. That we are trying to pull our end on this side, and on this other side, we're also trying to pull our end. In essence, where we will meet is at the middle, where we have a system that really works for us and works in the best way possible. I think I'll rest it at that. That is as much as I was to share with you this morning, and I'll be happy to take questions. Thank you.
Thank you very much. You could do a better round of applause for the panelists. Several things have been mentioned. I'd want to do only 3 questions on 3 different sects. One, pre-election, during the election, and the third, after the election. Pre-election, my question would be, how can we enforce values, Article 10 values, in 3 spaces? 1, the political parties before they give us candidates. 2, after they have given us candidates. 3, when they have decided to campaign. We haven't voted yet, but they're out there campaigning, and they are committing what you would consider an electoral malpractice. What is the role of the political parties in those 3 sectors? And does the legal framework as is provide a mechanism where we can have accountability and still uphold Chapter 6, and especially the values as established in Article 10? We could start with yes.
Thank you for those lovely questions. I think what we can do before elections, and one of the things that is required before you contest for office, even for political parties, will require you to have clearance forms. So the first gatekeeper of Chapter 6 is EACC. EACC can simply they reject your request for clearance. But EACC has not been doing that. The second point of call, which now brings political parties, is political parties have the latitude of, no one has a right to get any ticket in any political party. Political parties can still, they can still tell you, no, we are not giving you a ticket in our party. So Jubilee has done it before in the last elections. There's a candidate in Mombasa for the MCA position. who was denied the opportunity to contest for a ticket under the Jubilee Party. Political parties, what they can do right now is there are certain candidates who are corrupt enough not to be denied the ticket, but are not, maybe they don't have that much profile yet to cause chaos. And I'm talking about some of the NYS suspects, we know them, who have already declared interest in contesting for office. A political party can simply tell you, no, we don't think you espouse the values of our party, please go find it in another party. That is the first point of call that a party can make. And then they can also enforce the standards of Chapter 6 during the nominations process. As in, they can simply say that even though you are cleared by EACC, we ascribe to a higher standard, so we will not clear you. After the primaries, political parties are allowed and mandated to whip their candidates and even withdraw their nomination certificates. If you are cleared by an election party and the candidate engages in action that does not meet Chapter 6, if they go inciting, if they decide they will no longer be patriotic to the country, if they engage in anything, the party can simply withdraw that certificate. And what they have to do is just to write to IEBC, tell them that we have withdrawn this certificate because of this and this. It will become a dispute, obviously, but it's still something that can happen. And during the campaigns as well, political parties can whip certain candidates, they can deny them access to party resources, and they can also just take the action of reporting them to the relevant authorities, including IBC, EACC, and these other parties. But in truth, it's very hard for political parties to do this because they are looking at numbers. So they might not be the best vehicle to look up to, but they have a role nonetheless.
Yeah, because my follow-up question was to be, you had intimated to the impossibility of IEBC to pass the regulations at the National Assembly, basically Parliament, and these political parties have those almost the same actors, so that if the case is, for example, intervention by political parties, it looks like a stage will certainly fail. My other question was, you have stated the involvement of EACC. There have been claims of it being an institution that is not independent. So from the premise, it appears to be that we are starting from, it's an independent institution that can make its decisions. Are we there yet? Are we at a point where the conclusions by EACC are entirely based on the law and the facts?
Yes, I think on EACC, the biggest issue we have with them is not even independence. Because to be honest, I think EACC are fairly independent. Among the commissions, EACC is one of the institutions that has been given the freedom to do its work. And we've seen high-profile individuals being summoned by the EACC. The question is not really about independence or the issue we have with them, but it's about, for us, we feel that they really don't appreciate their mandate and apply it ruthlessly, especially in regards to clearing people for office. I'll give you an example, and I know some of us may have sought clearance from EACC, right? How is that process for anyone who has been involved? Is there anyone who has gone to EACC to get a clearance? No one. Well, I know this side we have, because we've applied for jobs. But what happens is you go to the EACC website, you download a form, you fill the form in triplicate, and then you submit the form to EACC, and then you go back with a copy. So what you submit to whoever needs that clearance is a copy of the form you have filled. And that is the same thing that happens if you are contesting for public office. So what EACC will do is they will do a profile of you and a report and send that report to IBC or your prospective employer or anyone who needs that information. And when they send that report to IBC, for instance, for this case, it will be recommending so-and-so Derek has these cases. We recommend you should not clear him. Or he is okay, please clear him. So what EACC has done is reduced itself to an advisory body. It isn't clearing. If you compare with KRA, if you want a clearance from KRA, you either come out with a clearance certificate or you don't. If you feel KRA should clear you and it hasn't, you take them to court. So IBC will wait. It will tell you, you finish and then come. But EACC on the other hand sends an advisory. It's like KRA writing to IBC telling them, no, this guy has not paid some taxes. So you decide. We recommend you don't clear them, but you decide. So that is the issue we have with EACC. EACC is independent, but it has not understood its mandate. What we would advise them is you fail to clear these people, let them take you to court if they have an issue with you, and then deal with it. And IBC, Chapter 6, you are not the custodians of Chapter 6. Your work is tallying and elections. So stay away from it. If someone comes with a photocopy, a copy of the document, IBC can simply say, no, come with a clearance. This one we would not recognize it. So I think some of these institutions, you have to push them. And Dudley will bear witness. Sometimes we've taken these institutions to court, and they come back to court supporting us and abandoning what they have been doing. So EACC just have to be told the truth. Do what the law requires you to do.
Thank you. Thank you very much. Ochil. Yes, please. Before we do another round.
I think that was comprehensive.
I'd want your thoughts on past EACC clearing. Do you think the courts are responsive enough to still, ensure that Article 10 values are maintained? We have indicated that EACC's job is, you have not been cleared. We take you to court. When we take you to court, do we have a responsive enough judiciary that will ensure that Chapter 6 is enforced? From practice, those who don't know, Ochel is a regular at the Court of Appeal and a regular at the Supreme Court.
I think on the issue of Chapter 6, the court let us down. You've been told about the ICC case. These guys have cases of the ICC case. And later, there was an advisory opinion filed at the Supreme Court concerning Chapter 6. In fact, there were two. The first one, the court declined. And then, no, Kweli Party tried to join. The court declined to hear that advisory opinion, to give advisory opinion. It had been filed by the Kenya National Commission for Human Rights, saying that there's another matter, the High Court. That matter, the High Court, has never been heard to date. It was filed before the 2017 elections, meant to give guidance to the 2017 elections. We are heading to another election, it has yet to be heard. So the courts have let us down on enforcement of Chapter 6.
So it doesn't look like a gap will fix real soon.
Yeah.
Timothy, you have any thoughts? Okay, during the election, my question would be, you have candidates running all over the place, in their thousands these days for any post. What will then be the role of one, political parties and also civil society in those spaces to ensure, because I think also, for example, if you want to convict for an electoral malpractice, there has to be evidence. So are we leaving this entirely to the state or the petitioner, prospective petitioners, or what can a normal citizen do to ensure that these people are held to account during the election? Because, well, people are receiving money now, but not yet. They will receive a lot more. For example, if you're talking about bribery.
Who are you asking?
3 people, capable people to answer. So.
I think I will go first.
Okay.
First of all, coming from civil society, I think there is so much expected of us. As in you guys, people always ask us, what is expected from me? I think we are doing enough, and we exist in a gap. And I know this is an unpopular opinion, but if our government systems worked very well, we would be jobless. We wouldn't have the need for civil society. So we exist because this government is not doing enough. And anything that we do is just complementary. We don't have a primary mandate to do anything, actually. So as TI, one of the things that we will do is we are going to document these election malpractices. We will have a team of monitors who will be on the ground documenting illegal use of public resources during the campaigns. If there is a cabinet secretary or a governor campaigning with a government vehicle or chopper or banning our resources, we are going to document it. We are going to report them, and if need be, we are going to challenge them in court. We're also going to, we are contributing in shaping the electoral jurisprudence of this country. When we go to court over issues of Chapter 6, election campaign financing, the political structures of these countries, decisions that IEBC is making, like it will interest you that there's a bill in Parliament right now that proposes election results to be physically transmitted to the constituency tallying center and then to Nairobi. So it is departing from the Maina Kiai decision, which says results should be transmitted from the polling station straight to the national tallying center. So things like that, we go to court to challenge them, to defend the constitution. So that's what we are doing, and that is what we have been doing. But anything more will be to demand quite a lot from us.
The citizens appreciate the role of civil society, but we keep doing more for the country. Ochel, you have any additions, or Timothy?
I think I'll mention something that President Obama said, and of course it's in line with what my colleague has said. We are civil society, and the citizenry will always ask, so you did this for us yesterday, yeah? But what have you done for us today? So it's always a question of what are you going to do for us today? I gave you something yesterday, but what have you done for me today? So we'll always receive the backlash that there's probably not enough that we're doing. But I think, as my colleague has mentioned, it's imperative that whatever is going on behind the scenes is actually very impactful. When you look at a lot of the policy issues that have shaped electoral processes in this country, are as a result of petitions that were filed in the court, decisions that were made, and this really helped in terms of stemming some of the issues that would have brought a problem much later. Have we done enough? It's a question of perspective. We believe we are doing, we continue doing. It's not that we have completed, but we continue doing this. But I'd like to pose this question and this challenge to those of us who are sitting on this side, and also to you people who are going to transition very soon into practice, and you'll be moving to, some of you will go into practice, some of you will be going to civil society, will join us in this space, and it's imperative that you know this as at now. The role of good governance and the role of ensuring that the systems are working do not lie with civil society. As my colleague has mentioned, we only complement that effort. The work of protecting the democracy and integrity of our processes is the work of the government. Always has, always will be. But we stand as guardians to these processes for us to ensure that the government is doing what it needs to do. So we will not relent in terms of speaking out and ensuring that our voices are heard as much as we can, for us to speak truth to these processes and ensure that what is being done is what ought to be done. Yeah? But it will never be our work. As my colleague has said, there's a time that we will not be there. Katiba Institute will not be there. TI will not be there. IJM will not be there. But does that mean that the work of ensuring that these processes are protected ends there? No. Because we want to build the capacity of structures within government for them to take up this work and ensuring that the cogs inside their wheels are actually working and are working for the betterment of the citizenry. So we'll do our part, but we will ensure that government really, really, really does its work. And as it said, we won't be here just going to court every single time to ensure that EACC understands its mandate. Just get to a point where EACC actually understands its mandate, and it actually has to do what the law has prescribed it to do. But before it gets there, we won't stop making noise, we won't stop setting the record straight, and we won't stop doing what we need to do. Thank you.
Thank you very much. The last phase of my questions, and I would start from Ochil, the other side. Electoral malpractices have been committed. We are prosecuting a matter, for example, the presidential petition at the Supreme Court. If I got you correctly, it appears there is a responsibility, sort of, for the petitioner to, for example, if the petitioner imputes electoral malpractice, is it your view that the petitioner has to then submit evidence so that the individuals accused of those malpractices are held to account? Or, as the law is, his job is entirely to allege, and then that responsibility shifts to the prosecution to ensure that within 2 years, those individuals are prosecuted, held to account, or released from responsibility?
Technological challenges.
Sorry.
It's okay. Thank you so much. This is how I see it. In the election petition, you're not finding anyone culpable. No one is held culpable for anything in the election petition because that is a civil court. The court does not find anyone guilty, does not sentence them. It does nothing in the sort of criminal jurisdiction. It is a purely civil jurisdiction. Was the election conducted according to the law, or was it infected by malpractices, whoever committed those malpractices? Culpability is now under the Election Offences Act, and that belongs to the criminal court, must be conducted within 2 years by the DPP. So the petitioner could be a complainant in the criminal case. But when you tell in a purely civil case, to prove beyond reasonable doubt that there was an election offense committed, when it's just a civil case, you don't need him to prove that, you impose an undue burden. I was giving the comparison of the DPP who has 2 years to prove the same thing. You want the petitioner to prove that in the 3 days when a presidential election petition, for example, is read. In fact, they're given 6 hours, and then the other side to respond. Hearings take about 3 or 2 days. So they first have 14 days to collect the evidence, and then prove it in the 1 day the hearing takes, beyond reasonable doubt. The DPP has 2 years for that. It doesn't make sense, it's not needed. So that the standard of proof, beyond reasonable doubt, should be applied under the Election Offences Act in the criminal court, not in the petition. It's not needed anywhere in the petition. The law has changed. there were Wetangula cases why the law changed, and the Supreme Court, the matter went all the way to the Supreme Court. Rawal DCJ writing to say that there's a need to reform the law so that these two jurisdictions are clarified. Petitions and the criminal jurisdiction to deal with culpability for the criminal offenses.
So just a follow-up on that. When I allege that offenses have been committed, what are the judges to do when they are sitting as an election court? Because one of the critics of the Supreme Court decision in 17 was that there was a finding that actually offenses were committed, never pointed to who committed them, and we've never really seen any prosecution as arising from the conclusion of the Supreme Court 17.
Now, the law as it is now, the court may make a finding that an election offense may have been committed. And if the court makes that finding that an election offense could have been committed, the court may report to the, and then the DPP would prosecute. Initially, the law was the court shall determine if any person committed an offense. That's a criminal standard beyond reasonable doubt. For you to determine that someone committed an offense, then the court could impose orders, disqualify or things like that. Now the court is required to may or may not make that finding. It can or it cannot make that finding.
Thank you very much. Any responses from the other two, or we take questions from the plenary?
I'd like to have a rejoinder. And I would say as Transparency International, we were opposed to the separation the trial of election offenses as criminal and the determination of election petition. And the reason why we did so, and yesterday your patron was here, Kenya Council, Githu, and he said for jurisprudence, it is consistency is the most important thing. Before the new constitutional dispensation, the jurisprudence was always that if an election petition finds you to have committed election offenses and uses it to nullify an election, that is good enough. You can be convicted on it, but mostly it was you being denied the opportunity for contesting. It was grounds for you being debarred for contesting for those offices. The Wetangula petition created confusion because on the one hand, the court has to rely, the first thing the court has to do before determining whether or not to nullify a result is whether an offense was committed. It has to make that determination first. It cannot just nullify the results. It had to make a determination that election malpractices were committed, which went into the core of the results, and that thus nullify this result. So if an election court has to do that, then how it will be very confusing for us to view you as still innocent and very pure, that another court has to make a determination based on the same facts and evidence. So if we have to say what is happening now is that first of all, I don't know which threshold the court will use to nullify a result. For Wetangula, let me just use Wetangula as an example. The court goes through all the all the evidence before it. You are allowed to bring in witnesses, use all that evidence, and says, okay, we will nullify these results because of electoral malpractices. But then nothing happens to Wetangula. He cannot be debarred. He cannot be punished or convicted for that. So for us, we feel that it created confusion, where people would always rush to the election court because it's easier, get results nullified. And then the burden of prosecuting you is now you bring in the DPP, who was not even there in the petition itself. And we felt that it should be the same court doing it.
Just a follow-up on that. The Supreme Court in 2017 made a finding that IEBC did not point to a specific person. Wouldn't that be then problematic to combine both jurisdictions before an election court, especially also looking at the timelines that, for example, the Supreme Court has to make a determination? Because that would mean, for example, if we are talking about a Form 36 from some county deep there, then that means we have to give opportunity to that returning officer to make presentation before the court, because if it is criminal culpability, would indeed be unfair to make a finding without hearing the party being accused of participating in the crime, for example. It's easier if we are saying, Barasa made this, but what if it's an institutional-wide problem? Will indeed need more time than 14 days to actually, effectively prosecute those, identify and effectively prosecute individuals culpable?
Well, personally, I know that if you are petitioning for nullification of results, and one of the grounds is a malpractice which is committed by your opponent, then they will be in that case. IBC, if you are faulting IBC, I think it will be a very tall order to find IBC criminally culpable. It will be very difficult. But an individual, that this guy bribed voters, did whatever electoral malpractice, which went to the core of the result, then you'll have to sue that person. You'll have to be in the case. He can't be the first respondent in the case. You'll have to table evidence and maybe witnesses, and the court will have to look at the witnesses and the evidence and make a determination that there was electoral malpractices conducted by Derek, and use that as one of the grounds to nullify the elections. So, so the idea that now I have to be taken to another court to now be found criminally culpable, I think it's not practical.
Okay. Ochel, do you want 30 seconds to respond, or we listen to Timothy first?
We can go to Timothy.
Okay.
Yeah, I hope I don't disrupt your train of thought, Ochel. I think I understand where Derek is coming from, and the position in which you're placed to have to move through courts. But my considered view would be, and I think I'd share the same sentiments as Ochel, that purporting to expand the jurisdiction of an election petition court to be able to hear and determine a matter that ordinarily would be heard in a criminal trial would actually open a Pandora's box. Suffice to say, like what happened in Murwatetu, that it becomes a confusion that though the court was pronouncing itself on a certain aspect of a certain case, because of the common law jurisdiction that we serve, then somebody can use that as precedence to actually import it into another type of case and actually try and mix it up and use that same decision to implore the court to make a determination. All to say, it would really open a Pandora's box. My view would be, if we can strengthen the institution that is the DPP, that in a matter that really requires prosecution and them to make the decision to charge, then they will be able to speedily move and ensure that anyone who has been found culpable, and I think the law that has been espoused regarding the wording of shall and may, that if a court finds that, yes, there's a possibility that actually there was an electoral malpractice, then it will be the work of the DPP to move swiftly to ensure that the charges are actually preferred, brought to court, somebody is charged. I don't think there's anything that stops, other than the 2 years provision of the law, that stops the matter from being determined speedily. I think the provision is, it must have been within 2 years from when the election. Nothing stops the court from hearing and determining it as quickly as it can. So my view would be, in order to circumvent the Pandora's box that might be opened by expanding the jurisdiction of an election petition court, it will be important that to strengthen the systems that are already in place for it to be able to respond faster, for us to be able to ensure that it's an holistic process that we're able to ensure that these cases are being held.
Thank you very much. Ochiel.
Okay, now I don't have a mic issue. So, beyond the things you've already said, now there's also the element of fair trial. Before you are adjudged criminally culpable for something, you must be given the right to be heard, one. Two, you must cross-examine witnesses. Now, the presidential election petition, for example, is heard on paper. No witnesses are called. The lower courts have time and they can call witnesses. But what about the Supreme Court? 14 days, no time to cross-examine any witness. How do you adjudge someone criminally culpable without that fair hearing, which entitles one to cross-examine the person who gives advice? Number two, there's what we call the hierarchy of courts and precedent, stare decisis. The rectangular case already tells us that these two jurisdictions are different. So the Supreme Court has already seen that the jurisdiction of the election court and the criminal trial are different jurisdictions. The mistake we accuse it of is retaining the standard of proof that only applies to the criminal court for petitions, which are civil issues.
Thank you very much. That was all from me. I'll be glad if we have questions from the plenary. Yes. I don't know if we have someone helping, passing the mic. We could start this side so that there's order, and then we... If you need it to be answered by one panelist, you mention.
Okay, so my name is Peter Kariuki. I'm a fourth-year law student from the Kenyatta University. So from the discussions that I've had, I think we have, my question will be in two limbs. The first one is with regards to the impeachment of the current governors. Recently, I think it's 2 weeks ago, we had the court pronounce itself that the Waitito impeachment was in the right way, and there were sufficient grounds upon which his impeachment was done through the process of natural justice. So such a person who has even gone through the court process, and the court has ascertained that indeed he was involved in the malpractices, and right now we have him yet again in the ballot. Do we say, is it correct to say that there is indeed a gap there where, for example, when we have impeachment of these current public officials and the matter has gone to court, that the EACC should stand up to the occasion and have these individuals step down? Secondly, my issue is on the current discussion with regards to lifestyle audit. So lifestyle audit, we know it's ingrained in our laws through the Wealth Declaration, specifically Part 4 of the Public Officer Ethics Act. However, we still see that the EACC has not again risen to the occasion to make sure that it undertakes its rightful position of making sure that these members who are vying for these positions, they fit that standard. A good and comparative study I'd give would be like that. It is an unfortunate, the country currently is facing a crisis, but it has a very good practice with regards to lifestyle audit. Ukraine, where Ukraine and also Rwanda, it's through a study that was also done by Transparency International. So you see that before one vies for a position, that they first do a lifestyle audit, and before again one leaves office, they also do another lifestyle audit before they undertake to go through the electoral process again. So will we say that that could be a good reform that needs to be put at the doorstep of EACC, that in the way they put deadlines for party nominations and the way they put deadlines on having these members satisfy themselves with the registrar of political parties, that we should also have a system where these members who are vying for these positions, they first undergo the lifestyle audit and before they are cleared again to proceed. Because as I heard you, you said that indeed it's only just a paper which you have, and that is sufficient to have you cleared. So would we now ingrain this lifestyle audit as the wealth declaration systems into our systems? Thank you.
Thank you very much. I'll need to take one more question, but be very brief because we have to release one of the panelists. And it is to our benefit to get his response at least on one or two of those questions.
Yes, thank you very much. I'm Ponde Emmanuel.
Can we do 20 seconds?
Yes.
Okay.
My question is about the standard of proof in civil cases. I think it's not something new that in a civil case the standard of proof can change. For example, let's say a civil matter whereby an element of a criminal offense is alleged, then which is important for the determination of that case, then the standard of proof changes. For example, let's say a matrimonial dispute, then in that case the standard of proof will change. So why is it that an election petition, where it is an election court, and then let's say the same offense in a civil case, let's say a matrimonial case, it is the same offense here. Why is it that we cannot use the standard of proof for that, the malpractices that have happened to be determined? I think we need to, for the word of the day is we should have consistent jurisprudence. So why is it that in election petition, the standard of proof cannot change? Thank you.
For the panelists, allow me to start with Ochiel. The gods are against you again. Sorry.
What did you ever do to KU School of Law? She do me like this with the mics. Anyway, there's a very famous English case. I don't know if it's the Miners case that says that there are only two standards of proof, civil and criminal. You yourselves told me that when we began, that there are only two standards of proof. In a divorce case, for example, when you're alleging cruelty or violence, that's criminal, isn't it? It's criminal, assault, criminal. But in a civil case, the standard is beyond, on a balance of probabilities. It never shifts. It never shifts. They're just two, civil or criminal. There's an English case. I'll find it and I'll give it to you.
Thank you very much. Do you have any response for the questions?
Maybe I can take them after they're
Okay.
done.
I want us to give a round of applause as we release Ochiel. Ochiel has to join another meeting right now. Thank you very much for coming. It was a pleasure having you on the panel. Thank you very much. We'll continue, finish the round of questions, and then we can have responses from the two panelists as we conclude. There was a question at the other end.
Thank you. My name is David Minor. The question I had, actually, Mr. Ochiel had answered it. However, I'd love to add on to it. What really is the burden of proof? If you study the electoral jurisprudence in Kenya, you'll find that in some instances, in Raila 1, and of course in other cases, the court cedes that some malpractices have happened, right? But then they say that these malpractices haven't reached a level that will nullify the elections. Well, this beats logic of beyond reasonable doubt. Well, if you use beyond reasonable doubt, then if you have any malpractice, then it will be nullified. On to the second question. My second question is, whose job is it to uphold the aspect of leadership and integrity and electoral misconduct? In the discussion I've had, the court, EACC, and political parties. When you look at the court, we should not fall into oblivious of the fact that sometimes courts follow what the society says, what the public says. Look at the ICC case, look at Sonko and how the public viewed him, look at Waititu and how the public viewed him. Then whose job is it? When you look at political parties, if we say that political parties should vet these persons, you'll find that these leaders are the same people who run the political parties, or rather who run the show. Then should political parties be granted that mantle? I also love the idea of where the gentleman in the middle has said that AKMCC has a role to play. Yes, thank you.
Thank you very much. Yes, we could take that too. And then conclude the panel, because we are really out of time.
Thank you very much. My name is Lemayan. My question touches on the ethical part of the questions of the issue before us today. And basically, it is on the aspects of governors trying to vie on different positions. And the part that I'd like to touch on is governors, for example, wanting to be senators. The important issue with this part, this specific part, is because the Senate plays the oversight role of governors. And you'll find some governors have cases, pending cases before the Senate, a body that is investigating them. And now they want to go and occupy the same seats. So what those ethical issues, I'm aware that right now we have such a case in court, I think it is by Katiba. What ethical issues do arise, and how can we stop such people from turning to be their own judges? Because you are a governor right now, you commit electoral malpractices, you commit corruption cases in the office of the governor. The next year you are a senator, investigations are still ongoing. How are we going to stop these things? Thank you very much.
Thank you. We could take responses.
Okay, thank you for those wonderful questions. I'll start with the impeachments. Impeachments, from my experience, more of political process than legal processes. And actually an impeachment is a vote of no confidence. You don't necessarily needed to have committed an offense or a violation of the Constitution. And I think practically what happens is some of those grounds for impeachments are usually just smoke screens. But it's more or less a vote of no confidence. So impeachments don't really fit the legal principles that we are taught in law school. They are very political in nature. But I agree that there has to be some objectivity in impeachment processes. And I also agree that once you are impeached, then you shouldn't be cleared to contest for office. So it's absurd if, say, Waititu is cleared to contest for governor in Kiambu. It means that the people of that county do not believe that you're able to dispense your functions as a governor. If, for instance, maybe you're impeached on other grounds, maybe medical, then it can be argued that now you have sorted out your issues, you're of sound mind, and you're able to, you're no longer physically or mentally incapacitated from to carry out those functions. But if you're impeached on other grounds, corruption or vote of no confidence, I think you shouldn't be cleared. On the lifestyle audits, that is actually a mandate of the AKMCC. It's supposed to conduct lifestyle audits. That's why people fill wealth declaration forms. But again, I think it's just something that AKMCC has handled it with soft hands. It's something that it has not been very keen on. On governors wanting to be senators, yes, I agree. That's also another ethical issue we are grappling with. There's no legal basis of barring them from contesting as senators. But I think, and this is a conversation that we can even delve into further, the moment we had devolution, we had two systems of government. And personally, I've always believed that the first investigative body for a governor should be the county assembly. In fact, it should be the primary institution, because it makes sense to have a house investigating one. You see, like the National Assembly, the whole of it oversights the president or the executive or the national government. So it makes sense because the MCA is there, is more familiar with the context and the documentation. I think what we need to do is to strengthen our county assembly so that they are able to determine objectively and to finality almost investigations against the governor. The county assembly exists to protect the county government. The Senate exists to promote devolution, so that if there's a process of impeachment that did not follow due procedure, then that should be the Senate. But I've always had an issue with the Senate being an investigative body. I think the Senate has an appellate jurisdiction where it should only restrain itself to issues of whether the rightful process was followed. But the moment the senator starts investigating the governor of the House, opening up evidence, calling witnesses, I've always had an issue with it. But we are still young in that regard, and I think we will continue building our jurisprudence on the relationship between the governor. It's lower, it's even lower than beyond reasonable doubt. It's very low. Going by the Nancy Baraza case, we are saying there is another standard that exists. Even in criminal cases, they are the innocent until proven guilty is usually the final one. But when you are going to bail and bond, there is a standard that has to be met before you are given some of those conditions for bail and bond. When you are seeking interlocutory orders, there is a prima facie. That's also a standard, whether it's you likely have been committed. Even in criminal cases, before you are put on your defense, there's a standard that the prosecution has to meet, and it's not beyond doubt. So I think there is more than one standard, but we can. You can call us again. We have a proper discussion on that.
This requires a seminar. Timothy, Shell, do you have final comments now that I could use your presence before we conclude?
Read the Raila 20. It says cited there. Okay, first start with Moses Masika Wetangula and see what the Court of Appeals, the Supreme Court says about the nature of the election petition, what kind of jurisdiction it is. Then also Rawal saying that we need to differentiate these two, and that is what led to the Election Offences Act. Then go to section 87 and see what is left of that section. Kenya law has this function that allows you to look back in time at an act. If you just look at on the right side, there's that date line. You can click on it, and then there's a scroll down menu. You can pick the date you want to look at the state of the law. So it allows you to see the way the law read before. And then now come to Raila 2017 and see the cases discussed there. For your own interest, if you have the time, just follow those, go to those cases cited and see what the state of the law is in those other countries. It would enable us to discuss this issue further. It's an open area. Some of you, maybe one of you could do it for their coursework or for their thesis or whatever. It's an interesting discussion, though, as we've seen today. Thank you so much.
Thank you very much. Again, thank you to the panelists. On my far right is Ochel Dudley. That is the point you clap. . 。   . 。 . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . So I'll start again. On my far right is Ochel Dudley. Next to him is Mahandia Derek. Close by here is Timothy Thondu. And yours truly, Emmanuel Famba Barasa. That is the close of the second panel. Thank you very much for the organizers for allowing us to have this discussion. I hope that the discussion continues to be to a bigger space and more people to hear more voices around bettering our country, because really it is us for this nation, right? All the best in the remaining sessions. Have a good afternoon. The president has something.
All right, thank you so much for that wonderful panel discussion. Ours from the AKMCC is to thank you for accepting our invitation to sit as panelists in this second panel. And with us here is a small token of appreciation to you. And we look forward to welcoming you to future events of the All Kenyan Moot Court competition. So maybe I could just ask Mr. Ochel Dudley to receive his token of appreciation. And I'd like to ask Ms. Christine Wanjiku to come and award him. All right, thank you so much. And then next we have Mr. Derek Mahandia from Transparency International. I would like to request Mr. Milton Duro to come and award him.
You know, I knew, so I didn't leave.
Next, we have Mr. Timothy Thondu, and I'd like to request Ms. Cindy Amuka, who was a former committee member of AKMCC very many years ago, to come and award him. And lastly, we have this one. I'd like to request Mr. Martin Kioko to come and award Mr. Emmanuel Baraza. And lastly, on behalf of AKMCC, again, we have tokens for your institutions for partnering with us for very many years. So with me here, we have a wonderful token for Transparency International. Mr. Derek can receive it. Thank you so much. And then I'd like to request Mr. Emmanuel Baraza to award this to Mr. Ochel Dudley on behalf of Katiba Institute. That is it for this panel discussion. We shall proceed to have lunch, and then later on we shall come for our last panel discussion, where we have a wonderful panel joining us from as far as South Africa. So we can... All right, before we even break out for lunch, we have a partner who just joined us, and maybe we can give them a minute to acknowledge their presence. So, Haki FM. Haki FM. Please let's give them a round of applause. Yes, would you like to say something, just a word or two?
Good afternoon. My name is Joseph Lugano. I'm the station manager, Haki FM. We are really glad to be here, to be invited here. Basically, our partnership is through Legal Resources Foundation. I have seen it somewhere here appearing. Legal Resources Foundation is an institution that actually offers legal services to those who are not in a position to represent themselves. And as a reason, they needed to get a platform that would actually disseminate the information back to the people and to the marginalized and the like. So we are basically a legal radio station that provides a participatory tool. Sorry, I have such kind of stage fright, so I hope you understand that. I'm not used to this kind of thing. So we offer the legal participatory tool, which aims at ensuring that the Kenyan citizen gets the best out of the legal services that probably most of you and most of us would actually be seeking for. So why Haki FM? Haki FM comes into place so that it goes to the least fortunate, if I may use that word, not the exact word though, but at least, for instance, if you go to the slums and you find someone has actually been accused, like I've had some of you mention, someone has been, caught by the police, and unfortunately, a roll of bang is slipped into his or her pocket, and they end up in prison or probably in cells without legal representation, but with the presence of Legal Resources Foundation and the paralegals that actually join hands with them, what normally happens is they visit the institutions and they provide legal knowledge and legal services, and actually see how they can assist the victim to get justice. So Haki FM actually is here to see how much we can partner with you and see how we can join hands with other partners, other representatives who have actually joined this session, and see if we can actually bring this voice back to the people. So what Haki FM is here to do is to make itself present to you people and actually offer a platform for you as students so that you can come on board. What we happened to have done with some, I think were about 3 or 5 students, we had 2 who came for podcasts. If I can remember, there's John Muwasa, who's the deputy of the All Kenyan Moot competition. And then I had some other 4 members who also came for live interviews, and I'm looking forward to having 2 more for another interview, which is scheduled for the 1st of April. The purpose for that is to basically bring us into speed of what happens during the mood competition and afterwards. So what if you win the award, then where do we go from there? And yes, pretty much to look for an avenue where, as we can give you the platform, you come and you can have a discussion with your lecturers, you can question your lecturers, you can argue issues out with your lecturers, we give you the platform, you can bring in questions, and we let the entire fraternity of the School of Law to participate and actually get to share ideas. So with me, I have one of my presenters who is James Mabea. You can probably just... James Mabea actually hosts the evening show. It's called Corridors of Justice, alongside a lady called Salama Bakita. Unfortunately, she couldn't come because she had to remain behind to host the show. If you could just say hi, just briefly.
Habari zenu. My name is James Mabea Villa Besema. I host the afternoon show, which airs every day, weekday, Monday to Friday, 4 p.m. to 6 p.m., 4 to 5 the first hour, I just entertain you with, Moshene, what's going on? You like that, Cindy? And then second hour, we do administrative processes. Administrative justice, like for example, if you want to, get a birth certificate, how do you go about it? So you're free to partner with us, Mkuje. It's not an exam, it's a discussion. I've seen some of you, the few that we've worked with, sometimes mtu anakuja pale kwa station, then you open the mic, then there's a mic flight. As we are not used to the stage, so we kind of get scared of the stage. But behind the mic, we are so good. I hope we will be okay with this as time goes by. So, karibuni sana.
Okay, thank you. Sorry, time is not really with us. I'd like to Jua, one of us again, is a production assistant. It's called Brian Mwamba. Just you can rauna mengi ya kusema. Okay, again, it's thank you from the panel and the organizing committee, and we look forward to having you on board. Anytime, you're most welcome. Thank you.
So thank you so much. This is Legal Resources Foundation, which are our partners for the 10th edition. And once again, we appreciate them by giving them a token of appreciation to Legal Resources Foundation. Thank you so much. Thank you so much. All right, we can proceed for lunch at the moment. For guests, you can proceed to the first floor. And for participants, we can proceed to the other side of the school. Now, the time right now is around 1:40. So kindly let us be here by 2:40, all right? So thank you so much, and please let us keep time.